Okay, my name is David Beauly. I'm a reporter in Scottish Government's Planning and Environmental Appeals Division, commonly known as DPEA. With me today is my colleague, Ms. Leven, who's also a reporter. We've been appointed by Scottish ministers to hold a public inquiry into the proposed Beauly to Peterhead transmission line and to report to them our findings and our recommendation as to whether Section 37% and deemed planning permission should be granted. Today's session will focus on what conditions should apply should ministers decide they wish to approve the proposals. We're recording and live streaming this meeting to our YouTube channel. We retain the recordings for the purposes of informing the public and for training. So we'll take your participation in the call today as your consent to be included within the recording and the live stream. We have all of today to devote to this session, although I'm hopeful it won't take us all day. If we don't finish by 1 p.m, then we'll take a break for lunch. We'll also have a short break at some point during the morning at an appropriate point. I'm aware that negotiations between the applicant and other parties may still be ongoing. It may be that you're unable to confirm today that agreement on all matters has been reached, and that's fine. I'm aware that Nature's Scott was hoping to receive some guidance from Energy Consents on certain matters. Due to all of these complicating factors, we don't expect to go away today with everything resolved. However, we do hope we can get some better understanding of areas where there is still disagreement or uncertainty on some of the issues. As I think we confirmed earlier in the week, in addition to looking at the areas disagreement, there's also the question of multi-stage consent conditions, and we would hope to get some advice from you in terms of when they should be employed and what wording should be used to secure them. For any matters that we don't fully resolve today, there will be an opportunity for you to update your position if appropriate in your closing submissions. Before we start discussion proper, I'd like those who are speaking today to introduce themselves. Where there's an awful lot of you in the team, you probably don't need to introduce absolutely everyone, but anyone you think will be actually speaking, that would be useful. So could I turn first to the applicants team, please?
Good morning, sir. I'm Paul Reid KC, instructed on behalf of the applicant. I'm here with Ms. Coburn. There are a number of people in the room, and I think it will depend where our discussion goes, sir, in terms of conditions. So maybe when I bring someone in, they'll maybe introduce themselves. At that point, that might be the most helpful way to do that. Thank you.
Thank you, Mr. Reid. Yeah, that makes perfect sense for everyone, I think. From Highland Council, please.
Yes, good morning. My name's James Finley, King's Counsel. I have appearing with Francesca Glendinning today. On the call, we have Rhoda Bamford, who's instructing me, Jack Wiseman, Planning Officer, and Jane Bridge, who's a Senior Engineer in the Transport Planning, who may or may not be needed.
Thank you, Mr. Finley.
I apprehend Mr. Wiseman is going to be dealing with your initial port of call, save when it gets technical or legal.
Thank you. Florida Council, please.
Good morning, sir. I'm Andrew Miller, Principal Planning Officer.
David McPherson, Principal Planning Officer with Development Management also.
Thank you. Aberdeenshire Council, please.
Good morning, sir. My name is Rob McIntosh, Principal Solicitor at Aberdeenshire Council, and with me my colleague Elizabeth Tully, who will be speaking on planning matters, and we'll also have another planning colleague, Stuart Newlands, in the room with us.
Thank you. Okay. Or Birkhill and Bruncrew Community Council, please.
Good morning, sir. Ian Kelly from Ian Kelly Planning Consultancy Limited, representing Kirkhill and Bruncrew Community Council. I realise the difficult logistics you have today, sir. So yesterday, I spent the whole of the day going over the fine detail of the conditions. I can advise that we have nothing to add beyond what is already in writing in front of you. And therefore, I'll stay on the call, sir, but there's no need for you to come back to me unless any particular points arise. As I say, we don't need to add anything beyond what's already in writing in front of you. And I hope that helps, sir.
Thank you, Mr. Kelly. No, appreciate that. That does help. We still can't see you, unfortunately, but we can hear you loud and clear, so that's the main thing. Thank you. Do we have anyone from Strathyla Community Council? No, that's fine. Mr. Darley, we get heard from him before. Nature Scott, please. Nature Scott, anybody? I see you, but I can't hear you. I see Dr. Parrish, and I can see a room with, I think, 3 people in it. Oh, I can hear you now. Thank you.
So, like that's, yeah.
Yes, perfect. Thank you.
That's better. Apologies for that.
Sorry.
Yes, I'm Jacqueline Cook, solicitor instructed by Nature Scott in this matter, joined today by my colleague Anna Crisp. And from Nature Scott, we have Jennifer Heatley, who is the energy case manager for Nature Scott, and Dr. Dave Parrish, terrestrial ornithologist at Nature Scott as well. Thank you.
Thank you. Do you have anyone from Historic Environment Scotland? No, that's fine. And let's look at Ms. Allen. I think I saw your name on the list. Could you just confirm you can see and hear us and we can hear you?
Good morning, sir. Yes, Fiona Allen, Kenora Huntley.
Thank you. I can see you, hear you loud and clear. Is there anyone I've missed who's on the call who is intending to speak? No? Okay. Wait. We'll be using the applicant's list of agreed and not agreed conditions of the 19th of August as the agenda for this meeting. I'm assuming everyone has access to that. If not, please get hold of a copy because that's what we'll be talking about. My aim is to focus on conditions where it's clear from that list that there is, or at least at the time the list was last updated, less than complete agreement. I may also identify other conditions where we have a query. Quite possible that third parties might want to raise matters in relation to certain conditions, even when it appears that the councils, for example, are satisfied. So I'm thinking, Ms. Allen, particularly in your case, don't feel you can't raise a matter that concerns you just because others haven't raised it. So do raise your electronic hand, everyone, if you want to participate in the discussion, even if I haven't invited you specifically to do so. Ms. Leven will be keeping a close eye to make sure that I don't overlook anyone. On the question of multi-stage consent conditions, I think the first instance where one of those might be required is condition 7 related to compensatory planting. Excuse me, I propose we deal with the question of compensatory planting or mitigation of multi-stage consent conditions in the context of compensatory planting first. So when we get to condition 7, and then maybe broaden the discussion at that point to consider its wider use for other matters where significant effects are not yet fully identifiable. So we'll have a general discussion after or around condition 7 before we move on to the other conditions. Quite a few matters later in the schedule of conditions that would be attached to the planning mission where I think this issue arises, but we'll deal with it all in one hit, I think, after we've dealt with condition 7, just so we can focus on that for a while. Ms. Cook, I know you said last week that there are certain matters where Nature Scott might have more confidence in a planning obligation being used rather than a planning condition. So please do let us know which issues you think that might apply to, and we can talk about that. I know we had Mr. Reed's initial thoughts on that last week also, but I'm happy to talk about either as it crops up on the agenda as we go through, or maybe at the end if you'd rather, whichever. If there's any areas you or indeed anyone else thinks would require to be subject to planning obligation rather than a condition, then do let us know about that. In terms of how the discussion would work, as I said, I'll be directing initially my questions to those from whom I think I need an answer, but please do everyone chip in as you wish. And then once I've gone through the list of conditions, if there are any other conditions that you think are missing from the list, then that will be your opportunity to add those on. So before we kick off, just if anyone has any points they want to raise or any questions about either this session or just in general, we might as well deal with that now. Mr. Reid, I'll ask the applicant first. Anything you want to bring up before we start?
Not specifically, sir, but I would want to notice that it's clear that significant work has been done on the conditions and acknowledge the working cooperation we've had with local authorities and others who've engaged in that process, which has yielded a significant degree of agreement. And we hope today's discussion will help that, and there's a continued commitment to working constructively with the interested parties to find the broadest consensus. But I think it is apparent there will be some issues where that consensus won't be possible, but do seek to narrow that as far as we can. But I wanted to start by acknowledging we appreciate the work and cooperation a number of people have put in with the applicant to get to the stage where we are today.
Thank you. Yeah, it's clearly not been easy when you have three planning authorities to negotiate with, and it's clear everyone around the table or the virtual table today has put an awful lot of work into this, which we're very grateful for. Anybody else? Mr. Finlay, anything from the Highland Council you need to say now? Or
No, I don't think so. Thank you, sir.
no, Murray Council, anything you want to raise now?
No, sir.
Aberdeenshire?
No, sir.
No. Anybody else? No. Okay, no. So turning to the conditions, condition one was the first one where there was a little query that I had for Mr. Kelly. Actually, this is the one occasion where we'll ask you your input. You feel, I think, 5 years, which is the default time period, should be shortened, given the applicant's position that time is of the essence. They really want to get cracking on this. I just wonder how strongly you feel about that. And if you do feel strongly, can you explain why a shorter period of 2 or 3 years would be justified?
Thank you, sir. I don't know whether you can see me. I hope you can hear me okay. You received an email yesterday from the applicants, again pressing for an early determination period in the application. In my mind, as a planner, that is simply illogical to rush determination and then say we need 5 years to start the development. It is just illogical. If there is a rush for determination to meet a timeline, then there must be an equivalent rush, which I don't agree with, but there must be an equivalent rush to commence development. It just seems, as I say, illogical to look for 5 years if you then are pressing for an early determination. So it's a matter of logicality more than anything else. So.
Would you accept that if, contrary to the applicant's clear wishes, something went wrong and they did have to take advantage of 5 years, given that at that point ministers would have accepted the scheme as accepted, would you accept, what would be the harm in development not commencing until 5 years potentially from the date of consent?
It's not a question of the harm, it's a question of the balance between the time taken to assess and determine the application and then start the development. It's not possible to say off the top of the head whether any particular harm would arise. As I say, it's a matter of logic. It seems to me that if you are pressing for a very early determination, then you must have in mind, an applicant must have in mind a wish to start the development in the early course. It makes no sense to press for very early determination and sit on their hands for 5 years.
Okay. Mr. Reid, could you live with anything less than the default 5-year commencement period?
So the first observation is a standard form of a standard condition. In relation to the timing, as I have sought to emphasise, there is a timescale fixed at the UK level for the delivery of this nationally significant infrastructure. It has a long stop date in 2031, which there are significant consequences of that not being met. So the applicant, it desires to do everything it can to work within that. The for my part, there's no reason to depart from what's the standard terms of a standard condition. But the applicant's clear commitment is to delivering this within the timescale which has been set at UK and reserved levels.
Okay, thanks. I don't think we're going to get any further on that. Nobody else had
Can
any?
I jump back in?
Please.
Obviously, this application will be determined at some point in 2027. A 5-year start period would actually go beyond that delivery date of 2031. I rest my case.
Okay.
Can I just ask a question? That we've got a message popped up saying that Copilot's been used in the meeting, and I just wanted to check where that was happening and what that was for. Is that relating to transcription, or can somebody confirm?
Yes.
Mr. Reid, do you know if that's anything to do with your transcription?
Well, from the looks of the faces around the room, it doesn't look like it's anything to do with us.
Okay. Well, if anyone is using it in the meeting, can you just advise us the purpose of that at some point? Thank you.
Thank you. Okay, so I had nothing on condition 2, assignation 3, serious incident reporting, or 4 in relation to land rights not having been agreed, or indeed 5, final energization are all standard conditions. So I was proposing to move to condition 6, the Kellis alignment, unless anyone else has anything on those. No? Okay. So condition 6, Kellis alignment, I think, question really for Murray Council, I think your concern is not necessarily the wording of the condition, but you want somebody to point out that, as you understand it, both the Kellis alternative alignment and the original alignment remain options for ministers to choose between should they decide to grant consent. Is that where you're coming from? The ministers could choose the other option, you say, is that right?
Yes, sir, that's correct. Both options are on the table. So it's just making clear if the preferred route is taken forward, that condition is dropped, and if the Kellis alternative alignment is taken forward, then we have no issue with that condition being included.
Just with Mr. Reid, the applicant, is it the applicant's position that the original alignment is no longer on the table, and in fact you're asking ministers only to consider the Kellis alternative? Is that your position, or are they both indeed on the table?
The position in the EIR was if the Kellis from wind farm was consented, we would develop the Kellis alignment. It has been consented. So that's our principal position. The condition reflects that.
Okay, so effectively ministers are only considering the alternative alignment. That's the basis on which they would be assessing the proposal, and bearing in mind Murray Council's objection to that alignment. Is that right?
Yes.
So thank you. Clear on that. Okay. Condition 7, which was the compensatory planting scheme, where I suspect things might get a bit more complicated for us, at least, to understand. So the condition requires a woodland planting scheme, which needs to be submitted to and approved in writing by ministers prior to commencement. Then there's a later deadline for the details of the replanting scheme, which would not be required until energisation. I know Aberdeenshire Council and the Highland Council have some concerns about when the final details would come in. The concern being they shouldn't be left to such a late stage in the process. I understand why the councils would like to know sooner rather than later what form the compensatory replanting would take. And usually, I think ministers would simply need to use their planning judgment as to what would be a reasonable and appropriate time to have that information, whether it should be pre-commencement, pre-energisation, or somewhere in between. I might be overcomplicating matters, but it struck us that Rachel Farms has reminded us that we need to consider whether the compensatory planting works might be part of the overhead line project, and if they are, whether the EIA regulations remove that discretion that ministers might have had as to when they get the environmental information on those replanting proposals. Regulation 4.5 of the EIA regs requires likely significant effects of proposed development on the environment to be identified before a decision to grant Electricity Act consent is made. We can't do that in respect of the compensatory planning because we simply don't know where it's going to go or what form it's going to take. So our understanding is we would need to see whether the exemption that's provided for in Regulation 4.6 could be used for compensatory planting. We think that's the issue we need to wrestle with. Obviously, at this stage, we would stress it's a matter for ministers to decide what is the extent of the project in EIA terms and whether they have sufficient information on its likely significant environmental effects. So in the same way, the discussion of conditions, it doesn't presuppose that consent and deemed planning permission will be granted. Our raising of this issue in the context of the EIA regs and multi-stage consent conditions doesn't make any assumption as to what decision ministers will ultimately take as to what is the project in EIA terms. We just simply need to have sufficient information and sufficient help from you to be able to advise ministers of all eventualities. Will cover whatever they might decide is the project and what the consequences of that might be. So we asked in our email, I think, which went out on Tuesday, whether compensatory planting should be regarded as part of the same project as the overhead line for the purposes of EIA, or whether being a requirement that's imposed upon the developer, it should be regarded as something else, perhaps a separate project that's a consequence of the overhead line project. We asked this because it seems to us that if it's part of the overhead line project, which I think was the applicant's position when it responded to further written submissions to 1, then that might have implications for when the body that's responsible for environmentally assessing the compensatory planting, which I think is Scottish Forestry, and the authority that would sign off any multi-stage consent condition, which is Scottish ministers, will require the missing environmental information on the compensatory planting works. In other words, setting aside any matters of planning judgment that ministers might have exercised as to when they want that information, we need to discover whether you think the effect of the regulations means we have, as a matter of law, that information prior to commencement of development. So that long and rambling speech is leading up to our very much non-lawyers reading of Regulation 4.6. We note 4.6 refers to all or part of the development. We don't know what that means, frankly, and we wonder whether anyone else can help us with that. I'll just 4.6b. So this is the exemption where Scottish ministers don't consider that environmental effects are fully identifiable at this stage, where they're minded to grant Electricity Act consent for EIA development or to direct that deemed planning permission is granted, subject to a condition that all or part of the proposed development must not commence, excuse me, before certain matters in the implementation of that consent or planning permission have been approved by ministers or the planning authority, as the case may be. We'd like to hear parties' views on the reference to all or part means, if anything, for compensatory planting, and when, as a matter of law, we or ministers would need to have the details and the environmental information of that compensatory planting. I was going to, start with the councils, put Mr. Finlay in the hot seat. If you have a view on this, I'd be very, very grateful to hear it.
Thank you, sir. Yeah, I think as we stated in our written response, we don't mount a positive case that compensatory planting is necessarily part of the same project, and we remain of that view. The reference, certainly my understanding of the reference in 4.6b of the regulations to all or part is that it is simply there may be circumstances in which it would be acceptable, bearing in mind the purpose of the EIA regime, to allow part of a development to go ahead without full details of another part. So a suspensory condition would only cover part of the development. But have to say that in my submission, that is unlikely to be the case, given the underlying purpose of the EIAR, which is that you shouldn't allow anything to go ahead until you've got the full understanding of the worst case environmental impacts. So I think it's simply there to give flexibility in a potentially appropriate case, but I find it difficult to imagine what that appropriate case would be. I think the draft conditions which we may come on to, which you've put forward and we may respond to in writing in due course, it seems to me that in this sort of case, you need to know if it is part of the project, you would need to know the impact of the whole project before allowing work to commence.
Thank you. That's really helpful. Yeah, I'm glad you said you couldn't contemplate what that might mean, or you couldn't imagine a circumstance in which that might arise, because we were struggling to come up with something where that might apply. So thank you for that. Borough Council, I know your lawyer is not with you today. Did you have a view as to whether you think compensation planting is part of the project or something else that's been, if you like, imposed upon the developer?
Thank you, sir. Our initial thoughts when we received your email was you made reference to be a consequence of the development rather than part of it. At this stage, we obviously don't know where it's going to be, but it's highly likely it's going to be quite remote from the development. The forestry EIA regulations have their own mechanisms to determine that. So on that basis, we'd be quite comfortable with it being dealt with separately.
Thank you. That's helpful. Mr. McIntosh, did you have a view on this?
Unformed a conclusive view, but I would say that not too dissimilar from Highland and Murray, and we'll pick this up in further written submissions to follow.
Thank you. Okay.
That's set up.
Thank you. Anyone else want to offer a view as to, or anyone disagree with that effectively, that it might not, these works might not in fact or in law be part of the headline development? Any disagree with that? No. Mr. Reid, so back to you. Are we in fact saying, Ms. Allen, sorry. You're on mute.
Apologies, sir. I would be surprised listening to the arguments put forward how it can't be seen as part of the same project because one relies on the other. So therefore, to me, they have to be inextricably linked. But that's just an observer's point of view.
Thank you. Mr. Reid, did you want to come back on that? On whether, well, first point, do you think they are part of the same project or something else?
It doesn't form a requirement of the condition. I think we acknowledge they are part of the project. But what you'll not be surprised to hear me saying, I'm going to reflect on having heard your concerns, sir, about this issue, and they'll be addressed in written submissions. I'm also conscious of a consistency with other projects. I will reflect on the discussion. I would make these observations at this point. We are reminded by the case of Fry by Lord Sales that there's a purposeful interpretation of the regulations, and in that case, he took the view that the precautionary principle would be defeated rather than promoted if the regulations were read as precluding an opportunity for an appropriate assessment at a later stage. Now, it's in the context of habitat regulations, but I stress the point that the importance of a purposeful interpretation gave effect to the underlying objective of that. We are told in Rayshaw that nothing there is inconsistent with Fry, and the concern that exercised Lady Wise was in whether it was impossible to assess at that early stage, and she wasn't satisfied that it was. The other general observation I make at this point is, in terms of multi-stage consenting, I do come back to the concern about the condition being reasonable in all other respects. That includes the timescale for the delivery of this development. and imposing a condition that would make that practically or realistically impossible to achieve seems to me at least arguably not reasonable in all other aspects having regard to the regulatory framework that's put in place. It's also at least of doubtful executive competence, given the reservation of transmission and distribution of electricity in this matter having been set at UK level. I will give you a more considered answer in writing, but hopefully that gives you an idea of at least the headline points. If I may, while I've got on, without going back to Mr. Kelly's point about delay, I do know that the timescale is ultimately a matter of UK government policy. So whilst that's the current timetable, we are not in control as to whether that date changes, whether for a range of matters of force majeure events, and that's the context in which there may be a consistency between current UK government policy and seeking the standard point. Sorry for hijacking this discussion with that point, but I didn't want to forget it for later. Thank you.
Thank you, that's helpful. Before we move off the legal question, and I'm grateful for what I've heard, I think subject to what you say in your written submissions, I think that I can see an answer to my non-lawyer's brain as to where we might go. But was there any other legal points? I wanted to raise some sort of planning judgment-y type questions, but anything on just the law before we move on? Okay, so just going back to, yes, sorry.
It may or may not be appropriate to raise it now, but it's a point that in terms of the law that underpins some of Highland Council's submissions is that if one concentrates for the moment on regulation 6A and the words not fully identifiable.
Yes.
There may be a difference between the parties as to what that is getting at. Highland Council take the view that that should be interpreted as not capable of being fully identifiable rather than not having been identified.
Yes.
And there's not a crisp line between the two, but it does seem that this provision is there to ensure that that where likely significant effects are not fully identifiable at the time of their determination, there's scope for moving the project forward. But it appears to Highland Council that should not provide a way out for parties simply not assessing likely significant effects that they're capable of identifying at the time of the decision and leaving that to a later stage, because that would be at odds with the purpose of the directive. And that submission will underlie a number of the related points that we make in respect of an appropriate condition in respect of this issue.
Yeah, that's helpful. Mr. Reid, do you want to come back on that? I appreciate you'll be addressing this in writing. I want to say at this stage, just
I think I'll wait and address it in writing rather than prolonging a legal debate at this stage.
Fine. Just as a heads up, we will be interested in, particularly in the context of things like borrow pits, for example. I know the applicant's position is they're not required, and you've modelled the transport effects on the basis that everything will be imported, but I guess we'll be wanting to consider whether that's a reasonable position, and given that you haven't closed the door to borrow pits, and you could arguably have at least a stab at suggesting where they would go and how big they might be in the event that they were required. We'll be interested in submissions as to whether, I think my understanding of Mr. Finley's point is whether you could have had your best guess at assessing the environmental effects of those in the event that they were required, rather than simply parking it for a later stage and not attempting to go there. I'll just say that for now. That's the sort of thought process we will need to go through in terms of whether the expectations of the regs, in the light of what was said in Rayshaw, have been satisfied. So I would say no more than that at this stage. So I'll just come back onto matters of planning judgment, really. It was some matters raised by the Highland Council, really. I think there were three issues that I identified. The first, probably the most straightforward, was the should not refer to a compensatory planting strategy and a compensatory planting plan, just in terms of wording the condition might use to make it more clear what it is that it's securing. It is compensatory planting. Mr. Reid, would the applicant have any major problems if those words were simply substituted into the condition?
I don't immediately see there being a particular difficulty, but if I am corrected after this, then that'll no doubt be expressed in our closing submission. I don't see an immediate difficulty.
Thank you, that's helpful. Second point I picked up, setting aside what the regulations might permit us to do, if ministers decided they didn't need, as a matter of planning judgment, all of the details of compensatory planting up front, there's the question of when further down the road those details could come in. And I think the Highland Council's point was, in the event that energisation were delayed, that there should be another date, an alternative date sooner than that. So perhaps, I don't know, within 2 years or something of you submitting the outline details, you shall provide the full details in the event that energisation, which was going to be the original target for those details, were delayed. It sounds like that would be an unlikely event, but whether you had any thoughts on that, again, Mr. Reid, whether we could have some sort of alternative deadline for those final details to come in to cope with that eventuality.
I understand the underlying point, and it's certainly reflect on whether there's wording to address that. And as you note, sir, it seems unlikely that it would materialise.
Thank you. And my final point that I identified was a question for the Highland Council. It made reference to some sort of gate check process. I wasn't entirely sure how that would work. I don't know if you know, Mr. Finlay, what the council had in mind in that regard.
I think I'll pass this to Mr. Wiseman, if I can.
Thank you.
Thank you. Yeah, I think that the idea was just to have some sort of initial outline sort of details of where the scheme might be, just so that we have confidence that it's a site that's likely to be acceptable, it's likely to be suitable, sort of type of compensatory planting and amount, and I suppose as well to give the applicant confidence that they're going down the right line as well. So it would just sort of be sort of an interim step, I suppose, between the strategy and the plan that just sort of keeps things kind of going in the right way for both parties.
Understood. No, that's helpful. Mr. Reid, again, putting you on the spot, but if, do you see any, in principle, problem with that, some sort of engagement with the councils? So I assume it would apply to all. So between your initial broad outline proposals and, as you would like it, energisation stage, when they're all finally signed off, just engagement with the council that they can advise you that you're on the right track. Does that sound reasonable?
Not immediately persuaded it would be the requirement to be necessary. It may be something that's better dealt with in any sort of memorandum or understanding or the like with the council. But yeah, but my immediate reaction has been far from convinced it would meet the requirement to be necessary.
Right. On that memorandum of understanding point, and as I understand it, there's a need, although there probably is a need, for some sort of confidentiality over your negotiations with landowners and where this compensatory planting would be going. And I think you offered to engage with the councils on a kind of a voluntary, confidential basis, just to keep them apprised of what your negotiations are revealing, etc. I think I'm right in saying you were content to go that far without giving the councils any kind of interim approval stage. Is that right?
Yes.
Yeah, thank you. I'm Emily Johns, Nature Strategy Manager at the SSN Transmission. On the memorandum of understanding point, we already have a memorandum of understanding with the Highland Council that covers both compensatory planting and other off-site biodiversity enhancement, and it's already got kind of confidentiality or commercial sensitivity clauses in there. And we referenced it in the submission previously, but we'd be happy to enter into a similar agreement with the councils as well for this.
Thank you. Thank you. That's all. Anybody else have anything to say about compensatory planting? Yes, Aberdeenshire Council, please.
Just to say, we've had no discussions or have no understanding in respect of a memorandum a memorandum of agreement in respect of compensatory planting. So it's not something that we can actually make any comment on. We would require substantial more information from the applicant before we can make any observations on that. But we still maintain our position that we would be seeking for any information that be provided prior to commencement of development, not energisation, and we'll pick up and expand upon that in our submissions. Thank you, sir.
Fine, but in the event that ministers weren't with you on that point, presumably you would welcome as much engagement as you can get by some sort of confidential process, being informed as to how things were going if you couldn't get what you ideally would want.
We would, and any confidentiality agreements, because this has been raised in respect of other developments with SSEN, has to have regard to the relevant legislation under freedom of information, etc. But we'll pick up and deal with that under submissions. Thank you, sir. Okay, thank you. That's helpful.
Anybody else on that? No? Okay, no, that was really helpful. So as I said earlier, before we move away from the multi-stage consent conditions, I did want to touch upon the two alternative forms of wording that we kind of sketched out and sent to you earlier in the week. I suppose the first question is whether you think we would need to make a distinction between, on the one hand, elements of the project, assuming that ministers conclude that these are elements of the same project, where there is certainty that they are actually going to happen. We just don't have sufficient environmental information at this stage. They're not fully identifiable at this stage. So that's on the one hand. And on the other hand, things like borrow pits, for example, where the applicant actually doesn't know whether they're going to happen or not. It seemed to us that there needed to be, if they were to be required to be the subject of a multi-stage consent condition, it seemed to me that there needed to be two different conditions. We couldn't have a block on development going ahead pending the approval of certain details for something that ultimately transpired not to be required, such as borrow pits. So I suppose that's the first question. Do you think we need to have two separate conditions? And then we'll go on to discuss whether the wording we're proposing is anywhere near suitable. I guess I'll start with the applicant, Mr. Reid. Any thoughts on first on the question about things you know you're going to have to do, but you don't yet have, or you can't yet identify the environmental effects, and then things that you might or might not actually want to do. And again, you don't know the environmental effects. Do you think we need to have a different approach to those, if indeed we do need to deal with them by a condition?
If they have to be dealt with by condition, I can see the logic in separating them so we don't get into a situation you anticipate, sir, where you have a block consequent on something that we're not proposing to do. So I see the logic in that.
Okay. Good. Anyone else disagree with that point? Okay. Well, back to you, I guess, Mr. Reid. Sorry, Mr. Wiseman. Sorry.
I think on this issue, I suppose I guess as Mr. Finlay said, our starting point is if it's not if the effects are not identifiable, then but essentially then moving on to a multi-stage condition is the way to deal with it. But that first step would still be important to address first. I don't know if this is the best time to bring this in, but we added a condition right to the end of the schedule, which was intended to provide some clarity on exactly what is being granted deemed planning permission. So then, I suppose our view would be if it's included in that list of what's been granted deemed planning permission, then those effects should be assessed either in the EIAR that's been submitted with the application, or in the event that those effects are not identifiable at the moment, then they should be specifically referred to in a multi-stage condition. I think our position would be that any multi-stage condition shouldn't be overly broad, I suppose, and allow for sort of eventualities that may or may not happen. It doesn't give much certainty over what's actually being granted permission. I think particularly in terms of borough bits, that would be our concern.
Right. So your condition 61, I think it is quite tightly defined as to what these are the matters that you say are definitely going, assuming ministers approve it, these are the matters that they are approving, and it's quite tightly defined. It doesn't extend, I think, to things like borough pits, because the applicant hasn't said definitely that they will go ahead. But I guess notwithstanding that they're not approved under this or at this time, if ministers found that they were part of the project, they would still have to be approved prior to the project commencing, if my understanding of the regs is correct. So I guess that given that they might not happen, I guess you would accept that there is a need for a different approach for those matters. If we simply don't know if they're going to, they can't be a block on development. They have to be an optional. In the event that you might need them, then you need to go and find further environmental information and have that approved, and before you can actually start. Do you accept there's a need to make a distinction between those possible eventualities and those things that are, notwithstanding that they're not on your list, they are part of the project? For example, ministers will need to address whether, say, the substations are part of the project, and a lot of submissions we've received will argue that they are. Obviously, the substations don't feature on your list because they're not being granted consent by this permission and consent. But in the event that ministers consider that they are part of the project for EIA terms, the effects of those would need to have been identified. And obviously the applicant says, well, they have been, because there is an environmental assessment of those. So, so a very rambling point is that there are two different things. There are things that are definitely going to go ahead, which if they are part of the project, we will need to have environmental information about. And there are things that might or might not go ahead, about which we might not need environmental information because they might not happen. So that's a very long question. They need to be dealt with separately if they need to be.
Yes, I do see where you're coming from. Yeah, I think the concern would just be the if it leaves things too open. Yeah, there's not much clarity over what's actually being approved, I suppose. So I think for matters like borough pits, I suppose, yeah, if they were to be the subject of subsequent planning applications, when they are part of this project, then yeah, they would need to be covered by multi-stage condition here. So yes, I do see what you're making, and yeah, I do agree it would need to be captured here.
Thank you.
Well, perhaps I could add to that.
Yes, please.
That I think Highland Council would agree that you need to cover both of the situations that you've sought to cater for by your two draft proposed conditions, on the detail on which we'll come back on, but subject to Mr. Wiseman's point that they should be limited in their scope, that there should be certainty as to what is being approved or potentially approved under any approval.
Yeah. So turning to the details of, we'll start with condition A. So this is the matters that ministers conclude are part of the project and about which they have insufficient information on the likely significant effects because they're not fully identifiable. The condition would propose, it requires two things, and I'd be interested to hear whether parties think that this is a kind of belt and braces, or whether in fact those two things are, as we believe, required. So first, it requires that the details, the missing details, missing environmental information, is approved under the terms of this condition. And second, that it receives whatever consent or permission it requires. Our thinking, and as I say, we're not lawyers, we might be wrong, our thinking was that in order to be a multi-stage consent condition, the condition had to have the effect of signing off the missing details. And in order to ensure that the missing details were subject to whatever was the appropriate environmental assessment, it should require that, or it should refer to the route, the consenting route that it would require. So in addition, given that certain matters that could be part of the project will definitely have a separate consenting route to go down, the condition needs to specify that that has been satisfied and it's been approved under that route, in addition to having the determining authority sign it off under the terms of this condition. So two requirements. I'll go to Mr. Reid first. Do you think both of those, on the assumption that a condition is required and on the assumption that it applies to whatever we're talking about, whatever other element of the proposal, do you think it's reasonable to have these two consenting strategies in place, or is it kind of unnecessary belt and braces in your submission?
Repeat my current view, and this will obviously be confirmed in our closing submission. My current view is how it's structured is reasonable. My more overarching concern with the condition is the applicant who submitted requires to reflect phasing to ensure the deliverability of the project within the timescale. So not phasing a condition like this, we would be apprehensive in relation to the timescales, which takes me back to my general points, both about executive competence and whether it's reasonable in all the circumstances, those being the capacity framework decision taken at UK level.
Thank you. No, that's helpful. I would very much like to hear your points on that in closing, and in the context of our earlier query about what does all or part in the regulations, what was that intended to tackle, and whether that is intended to tackle a situation like this where it might be unreasonable to the prospects of developing the project by putting everything up front. So very much like to hear from that in writing. But I'm grateful for your clarification that it's not your view that we're unnecessarily adopting a belt and braces approach by requiring those two things in order to clear the condition. Did anyone else want to talk about condition A before I move on to condition B? No. Okay, thank you. So condition B, as I say, this was where there is uncertainty as to whether you might actually need to do it at all. Unless the developer is confirmed in writing to the determining authority that the element of the development that's in question is not to be developed, then no development shall commence until it's gone through the two approval stages. So it's whether that's the right way to deal with it. So the initial step would be that the developer, if it decides it's not going to do borrow pits, then it just simply needs to tell the determining authority we're not doing borrow pits, and then you can forget about that. But in the event that it hasn't done that, there would be a condition attached for each of those uncertain items like borrow pits that would say you need to have the details cleared as per condition A. So again, Mr. Reid, do you think that's a way of, if and when, or there will come a time when your client knows that they don't need to do certain of those things, where there's a question mark hanging over them, are you content that we can simply say the solution to that will simply be you write to Scottish ministers and or the councils and say we're not doing that now, and that's the end of the matter? Are you content that that will be the way to do those matters?
I will come back in closing. It seems to me that reiterates the concern about phasing. It should be recognised, sir, that the point at which it becomes apparent it will not be required, and tying that to that point having to be before anything is done would be a cause of considerable concern to the applicant for the reasons I've already given. Okay, yeah, please do address me on that. I appreciate some of these decisions will actually be taken by the contractor, as I understand it, so you may not have necessarily direct control over when that happens. So that's very helpful.
I had nothing more to say on those multi-stage consent conditions. As I say, I would very much welcome any thoughts that you have in writing as to how we can advise ministers on those in the event that it turns out they are required. I was planning to move on to the planning consent conditions, if that's okay. Yes, okay. Condition 8, we don't need to deal with. That's the same as Mr. Kelly's point again about the time scale for commencing development. Condition 9, which is about phasing. I think we've talked about phasing to some extent. Didn't have any extra questions on that unless anyone else did. I think the parties are in agreement with that. We just need to think about how phasing would fit in with the requirements of the EIA regs, if indeed that is a complicating. Next one I had a question on, or query, is forestry felling condition 10. Highland Council and Aberdeenshire Council are not content. I think Highland Council not content. Aberdeenshire Council, I think we don't yet know your views. I'll ask Aberdeenshire. No, I won't. I will. Yes, I will ask Aberdeenshire first. If you can tell us, Mr. McIntosh, what your views are on the petition.
I'll pass it to my colleague,
Thank you, sir. It's just to advise that we have now agreed the position with SSEN, and that was earlier this week.
Oh, excellent. Thank you.
Thank you.
So back to the Highland Council. I think your position is you're still not quite content, Mr. Wiseman.
We're broadly kind of accepting of the condition. The only addition we wanted to see was just to have sort of annual monitoring of the amounts of felling that's taken place, which reflects in the fairly long period of time it'll be taking. That will be going over, and just so we have a sort of an overview of the effectiveness of the this forestry filling plan. Other than that, the annual monitoring provision, we're with the condition.
Okay. Yes, thank you. I see that now. Mr. Reid, I think the applicant, the last note I had was the applicant is considering Highland Council's suggested tweak. Have you had time to consider that? Are you content?
Again, far from persuaded on a necessity basis, or by putting that burden on the other councils as well. Being conscious that my Highland Council are seeking it, the other councils are seeking it, and then it will be binding them. Well,
yeah. No, that's a good point. We would be working on the assumption that conditions would be applicable to across all 3 local authority areas. I'm guessing that it would be competent for a condition to be bespoke to each, but I think we'd rather avoid going there just in the interest of clarity. So I think our position to ministers would be that any conditions you agree in respect of the planning permission ought to go across all 3 application areas. So
can I just double check, Aberdeenshire, you said that the position was now agreed on this condition. Does that mean that you're agreeing that condition as set out in the draft?
Yes, ma'am. But we would welcome the addition, as Mr. Wiseman has suggested, about the annual monitoring.
Thank you.
Thank you. Okay, we'll deal with, I think, condition 11, and then we'll take a short break. Condition 11 might take a little bit of time because I know there's a fair bit of disagreement on it. This is about micrositing and limits of deviation. Also, we can understand the applicant's desire to avoid delay to the construction of the project, and therefore why it wants to avoid a situation where there's involvement of the planning authorities in signing off micrositing within the limits of deviation. We will be bearing that aspiration in mind clearly when considering what would be the appropriate approach. It struck us that if the conditions wording were defined such that planning authorities were content they could leave it to the applicant's discretion, then that might be a way to please both parties. The applicant gets the certainty that there is no unforeseen time delay, and the local authorities get the certainty that what the applicant could permit in terms of micrositing couldn't be unacceptably harmful. Whether it's realistic to actually get to that position is what I want us to sort of talk about. Conscious the applicant is need to have consistency with other schemes such as Kilovolt, where I think you've discussed this matter. I mean, our only response to that, I suppose, would be until such point as ministers have agreed something, it's all still up in the air. So we don't think we're constrained by what might have been put to the Kilovolt reporters in terms of what we might think is appropriate. And ultimately, cases will be before ministers simultaneously, so it'll be up to them to decide which route they want to go down. So I had 4, I think, matters I thought needed to be talked about in the context of micrositing and limits of deviation. There may be others. We do my 4 first. First one was in respect of towers that would be close to residential receptors, and whether there ought to be any restriction on towers moving or increasing height in those locations. I know it's a point Mr. Kelly's raised, others have raised it as well. A lot of the people we saw on site have raised this as a concern. If it were to get any worse, then that would be something that they would be very concerned about. I understand, as I said, the applicant's design not to have the planning authority signing off every micrositing move that they need to make. But at the same time, there is the issue about how relaxed one can be in close proximity to residential properties. I think the Highland Council had suggested defining a 200 metre zone of a residential property as being a sensitive area where micrositing would require council's approval. So I suppose the initial question is whether the applicant's views on the principle of proximity to a residential receptor as justifying some sort of council sign-off. Second, whether 250 metres proximity is a reasonable kind of figure. And I guess third, in terms of requiring council sign-off, whether there could be a finite time that the council gets to veto the applicant's proposed micrositing within that sensitive area, whether you think that could reassure you or address your concerns about an unspecified delay to the consenting process. So your thoughts initially, Mr. Reid, on those 3 matters on residential proximity.
Thank you. So I'll make these observations. You may wish to speak to others. I've got people who can both speak technically, which might be helpful to understand when micrositing would arise and the consequences of how that would work from a technical perspective. It might be helpful to hear that, and others that are more closely involved in this. I think it's important to keep in the context to the micrositing discussion, because firstly, the application represents what the applicant believes to be a buildable alignment. But the limit of deviation recognises that micrositing issues, which experience teaches us, are inevitable and when trying to do a development of this nature. So the starting point is it's an application that's believed to be constructible. The second issue is there is a formal change in control process which requires approval from the project manager, the environmental manager, and the environmental clerk of works, who also have reporting obligations or would have reporting obligations to the council. So the council's local authorities would be cited on this. I would also notice the principles for limit of deviation and are set out in paragraphs 3.62 and 3.63 of the EAIR, which are the context in which this will be done, which include a presumption in favour of avoiding sensitive environmental features, a presumption in favour of avoiding residential properties, and a presumption in favour of the proposed development's alignment. So there is a context in which this discussion takes place, which I think is important to notice. In respect of the principle, the concern the applicant would suggest is addressed by the conditions which ultimately require the environmental clerk of works to sign off on it, and they will have to be persuaded that it is appropriate to sign off on the micrositing decision, and they are appointed in the Act independently of the applicant. So that is there. So in a sense, what the council contends is a second level of approval. There's already independent approval of the micrositing. In terms of a 200-metre zone, the problem with any arbitrary line is arbitrary. And what is far better is to assess the consequences of any micrositing as it arises in relation to any properties that it affects, which is what is undertaken to do in the EAIR, and which in practical would require to be done to persuade the environmental clerk of works to approve it. It may be, and I'll reflect on this, it may be that requiring notification to the planning authorities, say 21 days before a micrositing decision is approved in relation to a sensitive area or a property, would give the local authorities time to consider it. Because if there is a rule, I'm very firmly of the view, the applicant is very firmly of the view, there has to be a timetable, a time period within which a decision is made, or the environmental clerk of works is entitled to approve it, for the reasons I've already given and which I won't rehearse again. Now, I'm in your hands, sir, whether you would like to hear some more technical information at this point, or any more detail on that, whether you'd like to go round others before that's provided. But I think it would be helpful to hear the kind of technical context to micrositing.
Yeah, I'd be very interested. I mean, I took from the discussion last week, I've forgotten who said it, but the view was very much, this is the scheme we want to build. Our flexibility, certainly in some areas, is actually very limited. As for various constraints, we would struggle to actually move things, and this is what we actually want. This, we genuinely want to do this, but it would help to understand a bit more, because there's a real concern, I think, among certain local people we've spoken to, that while they think it's bad at the moment, they could see it being far worse if it just moved, a tower moved slightly along the line or came slightly closer. So if we could discuss the sort of technical constraints and the procedures that are involved, I think that'd be helpful for us to understand, please.
Neil Walker, engineering manager, scheme. So I guess on the technical, it's worth noting sort of a first protocol. If we do ever have to microsite a tower, it's generally driven by something that we can't design around, be that geotechnical constraint, private water supply, unidentified utilities, something along those lines. Where we would look to microsite a tower, we would look as a first instance in a kind of hierarchy to move it in line with the existing alignment. But that has its own constraints in that we may meet different topographical challenges. So it may not be possible to site that tower in line. Moving the tower in line can have a number of other challenges as well. So shifting the tower changes the span lengths on either side, which can have structural implications for our towers. It also can alter the ground clearances on either side. We can work within bounds to change that, to change the tensions in the conductors, to make that work, but there are limitations on what those conductors can also deal with. So there are instances in which those limits may be met, which may then drive tower height increase, for example. So there's a lot of engineering challenges that go into that may push us to make those decisions. If we can't move that tower in line for some of those reasons, then we look to move the towers offline using our horizontal limit deviation. We have limitations on their tower types and how far we can move those. So, for example, an existing tower that is a suspension tower can only have an angular deviation up to 2 degrees from a straight line. Once we go beyond that limit of deviation, that then drives the necessity of a tension tower. So that kind of steers us down that route. I don't know if there's any other areas you'd like to consider that one.
That's very helpful. I take it from that your position, put very crudely, is you're not going to just modify things on a whim. You're only going to change things if you really have to for engineering on genuinely undiscoverable issues that have popped up that you weren't expecting.
Yeah, as set out earlier, we believe what we have put forward is buildable, but there are unforeseen constraints through our experience in constructing these that will come up on site that we cannot avoid. We're trying so soon.
Okay. I'd like to go to Highland Council. It actually takes us into the second of my 4 issues, actually, which was the role of the environmental clerk of works. And I think it was Highland Council who said in response to the applicant saying, well, that's another step that should reassure you that things will be looked at properly. I think it was the Highland Council who said that wouldn't necessarily guarantee the avoidance of unacceptable landscape and visual effects. My question for the council would be, actually, that would depend on who is the environmental clerk of works and ensuring that they have sufficient skills to consider such effects. I think condition 14 allows councils to be involved in the appointment of the environmental clerk of works. So provided that they do that job adequately, then surely you can give some weight to the role of the ENVCOW in on the council's behalf effectively, or acting on local residents' behalf to protect their position. So questions for the council, I guess. First, my understanding of your position, is that correct? You were talking about having a sensitive zone around residential properties. Second, do you accept that the environmental clerk of works, assuming that they are correctly qualified, could actually be a very useful regulatory step? Third, do you accept it that the applicant isn't going to just modify these on a whim? And yes, fourth, the question about the timescale within which, if the council were to be given a veto, if you like, the timescale within which you could exercise that role in areas where you had some concerns. Mr. Finlay.
So yes, just responding to those points, not necessarily in the order you gave them to me, but the Highland Council accept that the applicant clearly intends currently to construct the line as it's applied for, but as we've just heard, its experience is that there is at least a likelihood that in certain locations the position of the towers will have to change. So whilst that is an unknown at the moment, it's a known unknown, and that it's something that cannot simply be ignored. And that leads to my second point, which is that the EIA regulations are seeking to ensure that you understand, or the decision is made on a potential worst case basis. And without reiterating the evidence of last week, if a tower was to move 100 meters closer to a property, that could at least have the possibility of moving it from one side of the residential visual assessment test to the other side. And if that has not been assessed in advance, or a sufficient Rochdale envelope has not been assessed in advance to cater for that, leaving it up to an ECAO, however well qualified, to make that decision is at odds with the purpose of an EIA regulation assessment, which is why, and Mr. Wiseman may want to come back on this, but it's why my understanding that we would seek, and the particular dimensions may be a matter for further debate, to exclude moving towers closer to residential dwellings as part of a sensitive area, picking up on a process that's already in the EIA, or a concept that's already in the EIA, is a sensible way of dealing with that. In terms of the ECAO, certainly, and again, Mr. Wiseman may correct me if I'm wrong, but it is likely that the ECAO, most ECAOs currently deal with environmental matters of a more physical nature, rather than the having to undertake an assessment of the whether residential visual amenity test has been breached or not. It's a completely different assessment, and you had 3 qualified landscape architects last week giving you their views on that, and it's just inherently unlikely you're going to get an ECAR that's suitably qualified. But even if you did, that doesn't meet Highland Council's fundamental objection that you are still failing to identify the potential worst effects on dwellings and not drawing the boundaries of the Rochdale envelope correctly. Fourthly, as to timetable, I understand the point that is being made that you need a swift decision as to whether something is acceptable or not. And I'm not committing Highland Council to any particular timetable, but the concept of a timetable is acceptable. It obviously, if a movement is to be made closer to a dwelling, provided the application is made to Highland Council with appropriate visualizations, then a reasonably swift decision could be made. But simply notifying them that they're going to move something 100 metres and leaving them to work out what the implications of that may be, the timetable will be significantly greater. And the last point I'd make is to underline the point that a reporting obligation or a notification obligation for Highland Council is simply insufficient to allow them to take a positive decision. They must, if there's a chance that the residential visual amenity test is going to be breached, they must have the ability to say no, which could then lead to an appeal if absolutely necessary. It's a practical matter, and I reiterate that we accept that the applicant intends to construct the line as is currently proposed, but for those reasons, we consider that the current solution is unacceptable primarily from a legal perspective.
Thank you. That's very helpful. Mr. Wiseman.
It's just a quick thing to add, largely just, obviously, not adding to what Mr. Finlay just said, but in terms of the distance, it's not an arbitrary figure. It's drawn from our assessment of residential visual amenity effects, which obviously you heard last week. There are properties where we've assessed breaches of the threshold in excess of distances in excess of 200 metres. I believe the distance we actually asked for the buffer was 250 metres to ensure that it does cover what we've assessed already, with a slight buffer beyond that as well to capture anything that could be worse than what we have assessed so far. So it's not an arbitrary figure. And just to confirm as well, in terms of timescales, we would be agreeable to some requirement to agree within a certain period of time. I suppose, as Mr. Finlay says, it depends on what's required to be submitted as to how long it takes us to assess that. We generally have a good working relationship with the applicant on some of the projects in terms of being able to prioritise things and phase things. So we had a good idea from the applicant about sort of timescales, and if things were spread out, so it wasn't tens of microsites in sort of proposals going at the same time. Working around those details, in principle, a timescale would be acceptable.
Thank you. That's very helpful. Thank you. Aberdeenshire Council, please.
Thank you, sir. We would concur with most of the comments made on behalf of Highland Council. These were exhaustively debated in the recent teacup, so I don't intend to repeat all that discussion. Just a couple of small points. The discussion so far have focused solely on residential, but would point out micrositing can and potentially could affect additional loss of woodland prime agricultural land and could impact on the qualities of local landscaped areas. So it's not just residential. In terms of a timescale, yes, similar, we could live with that, and we would have to agree, however, that we'd have what the quality of information that would be provided to respond to timescale would be. Everything else I'll just pick up in closing submissions. Like I said, I don't want to extensively rehearse what's already been provided, albeit it's in a separate application. I'll just leave it there.
Thank you, Mr. Mac.
Thank you.
Yeah. When I said we're not bound by what you might have discussed with reporters on contorted teeling, doesn't mean we're not interested in hearing in your submissions where you got to on those negotiations, because it may well be useful to us as well. So yeah, don't feel you can't tell us. We'll just put a marker down that we may have a different opinion, and it'll ultimately be for ministers to decide where they want to go. Murray Council, I think you weren't entirely content with the micrositing. Was there anything else you wanted to add to what you've said before?
Thank you, sir. Just noting kind of parts and highlighting all the dangerous comments. I'll not add anything further on that. The only point I'd like to raise is the last minute inclusion of changes to the functional model type of towers included in this suggested condition that wasn't included in the EIA report. We do have concern that could cause potential issues. It could have quite significant impacts. Looking at suggested wording of Dean Chair might piece our concerns, particularly with the more sensitive areas that they highlighted, as well as in close proximity to residential properties.
Yeah. And also, just a further point, sorry, Murray Council, note the discussion here about, I think most councils are agreeable to a defined period of time in which they can respond to requests for micrositing. It's also that the timescale that's requested for that also to reflect in the possible likely event that any of the micrositing requests, catch another constraint like a gas pipeline waiver or something like that, to be able to, it might be that the micrositing request is solely the narrow gift of the micrositing request comes within proximity to, an ecological asset or something like that, or a gas pipeline. So it's just so long as that request reflects fairly what we would need to do to respond to that request.
Right. Yeah, it's an interesting point as to where your responsibility would end and whether the councils could simply look at it solely on visual terms or impact on residential neighbours or whatever, or whether, I think you're saying, you would feel duty bound to actually do your constraints mapping, maybe ask other people what other factors might need to come into play, which obviously would delay the time period you would need to get back to the council, to get back to the applicant. That's one approach, or whether the other approach is simply the basis on which you get to agree or not under this condition is tightly defined to just certain restricted matters like its visual effect or whatever, and the responsibility would go back to the applicant to make sure they don't shift the pylon on top of a gas pipeline or something. You see, there are two different ways of dealing with it, and in terms of, I don't know which way. I mean, the council may be more comfortable to do it as it always usually does it, which is to make sure that in agreeing something, it's not causing other problems. But I'm just thinking aloud whether, in fact, if there were to be a council veto and a time period for allowing that written into a condition, whether it would need to be focused so that you just dealing with certain matters and you're not, you feel like you're excused from having to go and look in more detail and consult other people. Could you live with that?
If so, for Murray Council, yeah, I think that is key, because the body would be that we're not through the intent or malice on the applicant's behalf, but if we were given a tight time period to look at a micrositing request, but it did raise other issues. It was, as somebody mentioned before, potentially taking more, national emergency woodland or something like that. That beauty came to view, that might have been a gift to sign that off in its entirety, as long as it was clear possibly through the in the consent granted that our remit is only to confine itself to matters of aesthetics, for example, and as long as that was clear, we'd be okay with that. But, you know, other parties, other issues may arise from that micrositing.
Okay. Yeah, thank you. Okay, so I was going to go back to the applicant. Really, there's a lot of matters up in the air, and we need to come to a view on them. The only matter really, Mr. Reid, I was particularly interested in was Mr. Finley's Rochdale envelope point. I think it's right, is it not, that you haven't sort of modelled a realistic worst case scenario? For example, proximity to residential property. You've shown the landscape visual effects, the potential for the threshold to be breached on the basis of the proposal you want to build. You haven't defined parameters which would say, well, this is what the effect would be if it were to come 100 metres closer or something like that. So do you accept Mr. Finley's point that, in fact, without some sort of formal approval, external approval, rather than just your own approval process, there's a danger possibly that the worst case scenario hasn't been assessed and that we could end up in a situation that is materially worse and possibly put us in legal difficulties? Do you accept that that's at least a theoretical possibility?
No, because it's not our internal approval process. The approval is in the hands of an independent environmental clerk of works. We do not decide, and the conditions do not allow us to decide that. I'm going to just make a couple of points that might be helpful to hear from someone else in the room. First, we have already considered areas of micrositing at the request of the Highland Council. We discussed the canal last week, which resolved, if it proved by or agreed to by Scottish Canals and others, would resolve one of the concerns. So we have engaged in that process. I think the second point that we have to keep in mind is that the EAIR 3.6.8 makes it clear that where LOD comes up, the relevant environmental information would be reviewed to establish any potential constraints on adverse effects. If it needs updated, that will be provided to the environmental clerk of works, not just RVAA or landscape, but the environmental information, and the environmental clerk of works will have that and will need to be persuaded to sign off the condition. Now, if the concern for Highland Council is ultimately the suitability of that person to discharge that, the condition in relation to the environmental clerk of works requires that they are suitably qualified to discharge the role, and they will have input in that in having the person that's in place. So the idea that the local authority should have a veto where you otherwise have approval from the project manager, the environmental manager, and the environmental clerk of works, it would seem to me it's neither necessary nor reasonable in all other respects. I think I wanted to make those points now. I also promised Ms. Taylor that I would only make a few bullet points and let her come in. I think it'll be helpful for you to hear from Ms. Taylor as well.
Thank you.
Thank you. Hello, yeah, my name's Jackie Taylor. I'm a lead consent and environment manager, and just really to build on some of the points that Mr. Reid has addressed, and to also just hopefully address some of the points that have come out from the aforementioned discussion. As Mr. Reid was saying, the environmental clerk of works would be required to review all technical and specialist reports, and it would be through our change control process, the environmental manager and SSEN would basically ensure that that was facilitated for the environmental clerk of works. So that would include any specialist reporting that's required, and that would be done independently through any consultants, etc., that would be secured for that piece of work. I think it would be really, and that's really important to emphasise, because that it's about that satisfaction that the authorities are looking for, that this would be dealt with independently and that there would be the correct specialist on board. The environmental clerk of works role is really to ensure that they have all the information that they need in order to make that decision, and they are well within their rights to obviously challenge that information before they come to a determination on whether or not a change control should be approved. So I think that's a key point just to be aware of as part of this process. I think also it's probably quite important just to know around the RVAA position, that RVAA would be included as part of that assessment, and the change control process basically ensures that really if there were any sort of material differences of an environmental effect, including perhaps a residential and visual amenity effect, that change control process would not be able to go ahead
or there may be another consenting avenue that we would need to consider, because it would take it out with the realms of the EIAR that we'd submitted and the RVA that we'd submitted. So actually the process as it stands would ensure that we were within the realms of any consent that we actually potentially achieved with that current process that we've explained. I think that's probably the key point. I think the only final point I would mention is that as part of that change control process, we do have, and the environmental managers within SSEN and the environmental clerk of works may do this, but currently they can also consult other bodies as part of that change control. So we may get in touch with HSCOT or SEPA if there's a particular issue to ensure that the information being determined was fully dealt with, had all the information available before that decision was made. So there is that process already part of the change control process as well. So yeah, I hope that provides just a little bit more detail around the sort of importance of the change control process and the rigour of that process that we apply, and we already apply it as part of our existing projects. Thank you.
Thank you. That is helpful. Back to no. First, we have Ms. Allen.
Thank you, sir. As I'm sure you suspect, I have quite a lot to say on this one, being a resident who is potentially going to be quite severely affected by what is already a known issue within here. We have things that aren't mapped correctly. We know that pylons are already going to have to move because they can't go where you propose to put them. We don't yet know where they may end up, because coming to the one project, we're informed that dependent on what happens with the Strathbogie hub, the whole route may change anyway. So there's a lot of implications there. There's no consultation ongoing with those who may be affected. And I'm not hearing anything that's been said by anybody so far as to where do the public get involved here, because this is really significant on our livelihoods.
Thank you. Okay, yeah, that's another issue as to what, if any, role in the event that authorities were given a veto, what consultation notification process would they undertake with those most affected, for example, within whatever window they had to respond. So that's another factor we need to bear in mind should ministers decide that they think that some sort of role for the authorities in signing off any changes is appropriate. Another complicated factor. I wanted to go back to Mr. Findlay just on Mr. Reid's point that does it all come down in terms of the Rochdale envelope point and whether there's been adequate approval of the actual environmental effects of the proposal? Is it all coming down to whether we can trust the ECAO to perform that role? Is that the council's point of view? It seems to me that that's the area of disagreement or concern between the applicant and the councils, that councils would like to be the ones as the planning authority signing things off. The applicant would like it to be the ECAO, given that they are independent. They sit in the middle. Is that? Would you be content that your concerns about Rochdale envelope and reasonable worst case scenario not having been modelled yet would be addressed by the ECAO being able to perform that function?
No. Ours is a more fundamental objection. I mean, even assuming, which we have practical doubts about, the ECAO can perform that function. Our concern is that without if the worst case effects have not been modified, there must be the ability of a properly constituted authority to say no, and that is not an ECAO.
Yeah, I thought that's what your position would be. Before I leave you, I had a question for the Highland Council. Maybe Mr. Wiseman, you answer it. Just a simple question. My note says Highland Council has queried why floating tracks should be excluded from the restriction on movement into areas that would have greater overall impact on peat or GWDTE. I'm assuming the idea of the exemption for floating tracks is they ought not to have or raise concerns on peatland. But I'd leave Mr. Wiseman to answer why you weren't content that floating tracks should be exempted.
I think it's a fairly minor point, really, but I suppose it seems to suggest that micrositing of floating tracks can result in additional effects that haven't already been assessed. It's just to ask for clarity on why that would be the case.
Okay. I'm guessing it's probably because they're confident there wouldn't be significant effects, but I understand your point. Yeah, is it safe to assume that?
If I would you mind if I came in at another point on this condition?
Yes, please.
So it's something I should probably have raised last time I was discussing. We asked for a couple of other areas to be included as sensitive areas, which were which were the areas where we'd raised landscape and visual concerns. So places like crossing of the Caledonian Canal and in the setting of Culloden. The point of that was to so that if mitigation was agreed for those areas, it can then be microsited away, I suppose. Elsewhere, we've suggested a condition covering Culloden. We haven't suggested a separate condition covering the Caledonian Canal. As I understand it, the mitigation that's been put forward potential mitigation by SSEN hasn't been committed to for the Caledonian Canal yet. So purely restricting the micrositing or retaining control over the micrositing in that area wouldn't necessarily achieve what we're after in terms of moving that particular tower out of that view down the canal. So it's just to flag that up. At the moment, we've only addressed that in this micrositing condition. It may be additional conditions required to try and capture that. We'll hopefully pick that up subsequent to this.
Thank you. Yeah, there is a condition on the canal somewhere, 39, I think it is.
Yeah.
Come back to that at that point. Sorry, Ms. Lehman.
I think that's in relation to Scottish Canals.
Yeah, there's a query as to whether Scottish Canals are on board, I think, which the applicant may be able to update us on, possibly. I just had one quick, I'll come back to Mr. Reid, see if he has anything else to say. I just had one quick query, not really a query. I said I had 4 points. This was one of them, which was the least interesting of the 4. It was just in relation to SEPA, who aren't here today. As I understand it, the applicant, they've changed their position from what the applicant originally understood to be the case and on which they had based their design. I think it's to do with moving from a 10-metre minimum buffer from watercourses to one based around some standard, I think, or 50 metres in certain cases. As I say, SEPA's not here. We need to come to a view on that. It's just whether the applicant wanted to tell us anything more, or can we just rely on what you've already told us in writing about your position in respect of SEPA's apparent change of position. So that point, Mr. Reid, and anything else you wanted to come back on?
No, I don't think so. I think if we deal with an annex A to the conditions document, it's in writing. So I think I'm happy with what we've said in writing about that.
Okay. Anything else on condition 11? I think it is. Yes, 11. Before we have a 10-minute break. Ms. Allen, your hand's still up. I don't know if that's a...
Yeah, no, I have raised it again. Thank you, sir.
Yes.
It's really, it's actually a question about the limits of deviation, because we're already knowing that things are going to have to move. So it's a question on, this is predetermination, and I'm just wondering how this relates to any conditions that then get put in, because at what point do deviations keep getting moved, if you see what I mean? So if predetermination, a pylon has already been moved, say 150 metres, which is within the buffer, that's deemed to be okay, but then does the buffer move? And therefore, has that assessment been undertaken, or when does that get undertaken? Before, because we're talking about in types of work, that's to me post-determination and starting to be, after post-consent. So at what point? At the moment, it sounds like you could keep moving 200 metres, 200 metres, 200 metres. So where's the start and finish of this within this process would be helpful to understand. Thank you.
Well, we will be assessing the proposal as detailed on the drawings that are before us, and that will be our recommendation to ministers based on what we have before us. If there are ongoing works that have already suggested that things need to change, those we have no details of those, so we're not taking those into account. So even if they are technically pre-determination, we would be regarding as post-determination changes in the scheme that ministers will be looking at if they decide to approve it is the scheme that's currently before us. So unless the applicant were to change the scheme that's currently before us, which we're not encouraging, then they will all come under the sort of banner of post-determination changes, which will be covered by condition 11 in whatever form it takes. Does that make sense, Ms. Allen?
It makes sense, but it actually raises further concern because for residents, that then means actually we have no clue where this project's going to land up and how then what then happens. It's you think things are going to be where they're going to be, but suddenly they're not. But then there's no inclusion of the people within that, as far as I can see, process post-determination. So if consent is granted, then things just happen. So suddenly you think from the route that has gone to ministers and they are approving, we think the plan is going to be in point A, but if this then gets determined later, it's now going to be in point B, which nobody knew anything about nor had any say over.
Yeah.
Therefore, I'm actually then looking to the councils of actually how do they then protect their residents and their businesses.
Yeah, no, I totally understand your point. And again, that's a matter, if the councils want to contemplate that question as well, in terms of if you were given some sort of sign-off process, whether, and if so, how that would incorporate the views of those who would actually be most affected by any decision to agree or not agree, a micrositing change. Anything anyone else wants to say? I was going to go back to Mr. Reid to give you the final say, unless anyone else wants to come in. Anything just on condition 11 before we take a short break? Mr. Reid, anything from you?
All I would notice is that the limited deviation doesn't change relative to a tower move. So if, for example, a tower moved 50 metres left, the limit of deviation isn't then redefined by reference to the microsite. I wasn't sure if that's perhaps one of the concerns that's being expressed there. But
Yes.
other than that, I don't have anything to add to the discussion, which has been helpful and instructive.
No, my point is when it moves beyond the limit of deviation because of geological or whatever reasons towers have to move.
I think we're content that the limit of deviation is based upon the location set out in the proposal that has been approved. If that ultimately turned out to be what happens, it doesn't keep shifting itself. You can't keep on adding 100 meters here and there. But I take Ms. Allen's point that she doesn't want to wake up one morning and find that the power has moved 100 meters and she knew nothing about it. What she thinks is the worst case is, in fact, it's worse than that. So I understand where you're all coming from on that. So can we take a break? It's 12 o'clock. Can we come back at 12:10 and we'll move on to the next condition? Thank you. Oh, we're back. Slight panic there. I couldn't see anyone. You're re-emerging. That's good. So, policy condition 11. My next query was on condition 16, but if anyone has anything to raise in respect of 12 is implementation and mitigation, 13 planning monitoring officer, 14 that was the aforementioned ECAL or ECAL, and 15 people advisor. Anyone have anything to say about those? Mr. Wiseman.
Thank you. Just it's a very brief point on the planning monitoring officer condition. Drawing from our experience on other lines and how they sort of work in practice, it would be helpful if the TMO could maintain a register of planning consents that cover sort of other aspects that are not given deemed permission by this. I suppose one, to ensure compliance with the EIA report, but also to ensure consistency from our side, so that we're sort of aware of everything that's come in, because it could be dealt with by a large number of plan officers across various offices. Obviously, it's for us to be consistent, but it would be very helpful for us if there was a list that said these are the related applications.
Okay. Yep. Mr. Reid, can you live with that?
I'm afraid we were only admitted to the meeting halfway through that comment, so I'm afraid I'm not.
Oh, sorry. I think summarize it briefly. On the planning monitoring officer condition, which is 13, Island Council were asking whether it would be possible for the PMO to be required to maintain a register of all of the associated permissions that go with the wider project and status of those, and presumably sign up for conditions and all of that. Mr. Wiseman was saying, well, obviously they appreciate they are the planning authority, but it would be helpful just for an overall part of this coordination role if they could, in addition to dealing with this proposal, be required to keep on top of all of the other consents that the applicant has secured as part of the wider project. Whether you could live with that being written into the wording of that condition.
I understand that might kind of routinely happen anyways, that planning monitoring officer, but I can see the sense in it being related in a single document or a single place.
Thank you. Ms. Allen, please.
Just before Ms. Allen starts, can I just say, when we have a break, you don't actually need to leave the meeting. You can just mute and put your camera off. So that should make it easier for coming back in. You shouldn't need to join. Ms. Allen?
Thank you. Yes, it just comes back to really earlier comment of the public involvement and knowledge of things. And again, looking at compliance, again, public on the ground are going to be more aware of whether there are potential breaches. Is this going to be well advertised so that the public know where to go and who to go to should they come across something which they wish to report?
Yes. Good point. I mean, your point of contact would be your local council. That would be the person to whom you should report any concerns. They would be responsible for enforcing any permission that was granted and any departures from what has been approved.
Have they got resources in place for such a large project to act quickly?
It's a very good question. I don't know. That's always a challenge. Okay, can I move on to the CEMP, Structured Environment Management Plan? I know the Council's raised some queries, which I'll ask about in a second. I just wanted to deal with SEPA's proposed tweaks to some of the wording. As I understand it, the applicant's concern or principal concern is with SEPA's desire to refer to future flood maps, and the applicant's point that, well, these are updated periodically and it's a continually moving process. So you're not keen to meet that kind of uncertainty. I just wondered whether, if the reference in the condition was to the SEPA future flood map at the date of approval, as to whether that might remove that concern about uncertainty. Mr. Reid, any thoughts?
Yes, it's if there's at a specific date, that would address the concern about subsequent change and that.
Thank you. So turning to Highland Council, I think you had two principal concerns or queries. How long you would get to consider the CEMP, the outline or the phased versions, and also in relation to protected species surveys, I think needing to ensure that there is actually adequate survey work being done, given that not all of the route has been surveyed. Maybe you can just, I think Mr. Wiseman, maybe you can just explain what you're looking for in terms of changes in those areas.
Yeah, I suppose in terms of the lead-in period, just reflecting the likely length and the amount of work that's likely to be required to go through the outline. And I suppose as well the potential for there to be some back and forth with amendments required. So the 3-month lead-in period is supposed to try and accommodate that. In terms of the protected species, I think at the moment there's a reference to survey updates informing the species protection plans. And obviously the approach to protected species surveys, I believe, was agreed with NatureScot. In terms of sort of more of a desk-based emphasis and then targeted site surveys, I suppose we would want to know that adequate surveys have been carried out on a phase-by-phase basis. So it'd just be to clarify that. I'm not sure if survey updates goes far enough to cover that.
Right. Yes, that's so. Question might be if more than a desk-based survey, if no on-site survey had taken place, and if the relevant experts felt that there was the need for that to take place, does the condition need to specify that it shall take place? And whereas at the moment a survey update might suggest something other than going in its stage, it might simply be a chronological update of a desk-based study, which maybe isn't sufficient. Is that? Yeah.
That's it.
Would you defer to the experts, if you like, at NatureScot on those matters? If they were content, would you be content? Yeah.
We would, I suppose. Yeah, we've taken that approach to the general sort of approach that's been taken with this. So it's something we want to flag up and for it to be considered. But yes, yeah.
Okay. So, so the question for NatureScot is NatureScot content with those elements of the CMP that relate to matters of concern? NatureScot, particularly species protection plans, which is dealt with in point 2D, I think, and an ecological and ornithological management plan or equivalent. There is reference to survey updates, etc. Is that phrase survey updates sufficient, or does it need to be more broadly phrased or differently phrased to contemplate a different type of survey or something potentially? I don't know. But simple question is, are you content with the NatureScot with the wording as it's set out?
Thank you, Sarah. Yes, I think I'd ask that applicant maybe to clarify, but from memory, the species protection plans and all sort of specify that pre-construction surveys will be done, and obviously that would be on a phased approach. So I guess survey updates, yes, in respect to the areas that haven't already had physical surveys on the ground, then it would not be an update, it would be a survey. But yeah, it's more from our perspective, we just really need to know exactly the pre-construction surveys would be happening to ensure that no protected species are obviously detected on the ground, so that actions can be taken if required to mitigate any impacts on that. Does that make sense?
Yeah. So maybe the precise format for the species protection plans and what is required to feed into those could be approved. It might not necessarily need to be specified in this condition itself. It could be something that you build into your agreement of those plans. So you won't sign off a species protection plan for whatever species X unless certain types of survey work have been done or certain something else. I'm just wondering whether there needs to be a change to the wording of the condition on its face, or whether you think that it could be dealt with by your or the planning authority, as it would be approval of the things that are required to be put in pursuant to this condition, such as the species protection plan. Or do you want it to actually say on the face of the condition, we need to have this, this, and this, you know, or the species protection plan is required to include this, this, and this, in which case you don't necessarily need to let me know now. Just if you thought that, just for clarity, it needed the condition, or the condition would benefit from greater specificity, then maybe think of some wording in your submissions as to how that might be improved, if you think it needs. Does that make sense?
I think I do. I think I understand. But I think it's best if we can be as clear as possible what information we would be receiving, and you know, at any stage, because I think, you know, we appreciate that, you know, that we'll want to get the pre-construction survey. So I think normally we would get some documentation of confirming what surveys are going to take place and when, and that is generally to ensure that they are done at an optimum time of year to pick up the signs of protected species, and then those surveys would be done to inform the sort of pre-construction thing. So I think, you know, yes, it's possible that the wording could be sort of tweaked to be more clear, and that might be helpful. I just there have been occasions I've had where wording has been very precise, and that has sometimes tripped us up in terms of trying to actually discharge the condition if it is too specific as to what is required, because not, you know, obviously there's a sequence of events that happens in order to get the right level of survey work and assessment done in advance of pre-commencement. So that's I think we would say is, yeah.
Okay, yeah, thank you. So going back to the applicant, say something very, if you wish, about whether the condition needs to have any more specificity in it. But I was mainly interested in the Highland Council's point about having 3 months rather than 1 month prior notice of works commencing on a particular phase, in order to give them sufficient time for dealing with the outline. It says 1 month in the condition. Could you live with an extension to that, giving longer prior notice to the council?
Go back to my concern about the timescales and the risk of delay. It's not entirely clear to me why 3 months would be sought. I'm not sure if there's a commitment to that not being seen as a long stop date or a target date, which it should be as soon as possible. It's not a due date, and I would prefer a strong preference for a month. I know that as part of the embedded mitigation, the applicant has committed to confirmatory protected species surveys for the full proposed development, as well as pre-construction checks. And I agree with the observation made about the risk of being overly prescriptive, and thus getting ourselves into an issue with discharge at that point. And I do wonder about necessity for the level of precision that has been sought. And that's the theme I might come back to when we get into some of the THC conditions later on.
Okay, yeah, thank you. Okay, we need to have a think about that one. So moving on to 17, which is the construction and traffic management plan. I think this one has been still up in the air. My note says, I believe we've received revised wording. This is actually, it's condition 18 as well, which I think relates to transport specific phasing. Maybe Mr. Reid can explain where you've got up to with the various councils and how close you are to getting agreement, if you are.
Looking down, some would be better place than me to say exactly where we are with the discussions with councils.
Yeah, this is Whiteley, Environment and Consents Manager, SSE. The back history of the CTMPs, we have different wording for it that became very onerous. There was lots of additions to it. And so we reverted to going back towards EC model condition and put that back around the council. We've agreed that with Moray Council, and Aberdeenshire confirmed their acceptance of that on Tuesday in a separate meeting. And so the outstanding issues relate to points delivered by Highland Council.
Okay, so if I go over to Highland Council, you have quite a long list of requirements in your version of the condition. Why should we favour your more prescriptive approach maybe than what's been agreed with the other councils? Mr. Wiseman?
Yes, it is quite a long condition. There's a lot of information requested by it. One of our major concerns with the whole scheme is the potential impacts on the road network and the level of assessment that's been carried out to date. I don't know if the report has been
back. You're back, I think.
Okay.
You can.
Yeah. Okay. Yeah, it's one of our key concerns is the potential for quite extensive impacts on the local road network. And the reason the condition's so extensive is because we would normally have a lot of this information up front, so around sort of kind of routing and vehicle movement levels. The information we have at the moment, where we have it is just not sufficient. So we have concerns on a number of areas about damage to the road, sort of impacts on the road users, and as we see it, the only real way we could sort of resolve that by condition is by requesting all this information. We've wanted to keep sort of the outline and then phased approach to make sure that effects that maybe extend over, amongst other things, effects that extend over multiple phases are properly considered at an early enough stage where they can be fully considered and if necessary kind of mitigated for at that point. So yeah, so we would prefer to keep it as outlined and then phased. Well, as Mr. Finlay mentioned at the start, I'm joined by Jane Bridge, who's our senior engineer. So if you have any sort of queries around particular points of the condition, we might be able to give you some more background on why we've requested that.
Okay, thank you. I may not need that only because this stage it may simply be more of a sort of a point of principle as to whether the condition goes into as much detail. It may be we simply need to go away and look at the problems that you've identified, potential problems you've identified, and just to help inform our judgment as to whether your more cautious approach than the applicant's is justified or not. As I won't be able to do that off the top of my head now, I might need your experts' input. There is a possibility we might need to come back to you in writing just to justify, or to him in writing, just if we need clarification as to why you have a particular concern about a particular technical matter, that we might need to follow that out. So I know, Mr. Reid, you have your own expert there as well. I guess they might be more useful to us today if they wanted to identify any particular areas where they think the council is overstepping the mark, just so we can feed that into our subsequent consideration of whether the more detailed or the less detailed versions of the condition should be favoured. I don't know if you're able to, or your expert is able to do that, identify any particular, or is it more of just a general overall approach of requiring too much information by condition?
Before going on, it's certainly on the screen I'm viewing, I saw Mr. Kelly's kind of box had lit up as if he'd put his hand up. It seems to have gone down. Again, I don't know if you just want to check whether Mr. Kelly wanted to come in on what had just been said. It's lit up again.
It has indeed. Well spotted. Mr. Kelly.
Yes, I was hoping you'd see me. The position of the community council, the client's community council, is to support that of the council in that there is so much information missing at this stage. The point I wanted to raise was, are you aware of the procedure notice that has been issued in relation to transportation matters for the Fanellan hub end of this project? It is very highly detailed. We have a dispute in that the local authority, the local community is not involved, but very similar issues are raised. And I think I can say basically there's an impasse between SSEN and the council in relation to what's to happen at Fanellan in transportation. So I appreciate that the whole racial issue has still to be resolved, but I just wanted to make sure that you were aware that this week a very detailed procedure notice was issued in relation to transportation matters, and the level of detail sought by your colleague is commensurate with the approach of Mr. Wiseman and the council to this condition. Thank you, sir.
Thank you. That's interesting to know. I was aware of the fact of a procedure notice, but not at all of its detail. We tend not to much of an overlap. We need to go ahead around what we think we need to know and what we do know at various stages, and it's useful. Thank you for advising us of that. That matter isn't before us, but I'm grateful for you letting us know at least that your interpretation of that is that Mr. Wiseman's justification or expectations of information is justified or is in line with what our colleague is thinking.
Can I just jump in? You say it's not before you, but this overhead line ties into the Fanellan hub in a very specific way, and the construction traffic for both aspects will overlap. So I honestly don't see how you can pretend that the Fanellan hub and its problems don't exist. They are a fundamental part of the resolution of the transportation issues for this overhead line because they meet at Fanellan.
Yeah, I wasn't.
Sorry if it sounds a bit blunt, sir, but that's how I feel about it.
I'm not at all trying to suggest that it would be wrong for ministers to look beyond the effects of this proposal, regardless of whether the Fanellan hub or any of the other substations is part of the project. There needs to be a consideration of cumulative effects because they are physically adjacent and likely, it seems, to happen simultaneously or contemporaneously, one of two. So, no, I wasn't I put it rather imprecisely. I wasn't trying to suggest that the effects of the Fanellan hub in terms of traffic or anything else shouldn't be considered as part of this in terms of cumulative effects and how the two schemes might interact, regardless of whether they're one project or not. It is a very important factor we need to take into account. My point was simply that the detail of our colleagues' requests for further information hasn't been put before us, if you like. So I haven't seen it, haven't read it. So the issue is very much before us. The interaction between the two schemes or multiple schemes, I just don't know the details of what they've asked for. So yeah, we need to satisfy ourselves whether we have sufficient information on those cumulative effects or whether we need any further information. And part of that will feed into our discussion as to whether Parliament Council's request for more detail via a condition to sort of plug what they see to be information gaps is reasonable or not, or on the alternative, whether we can rely on the less detailed proposal put forward by the applicant. So yeah, I didn't want to give the impression that we were not considering how Fanellan, etc., might interact with our scheme. We very much are. It's going to be critical, obviously, if lots of work happening at the same time or very similar times. Very much a live issue. Back, I guess, to the applicant, just to see what you think or what your response is to the Highland Council's more detailed requirements under this condition.
Thank you. Sorry, it is the more principal concern that's the applicant's position. The standard model condition is sufficient in this level of detail is not necessary or appropriate, and in a sense at the same position. So your colleague took in the Kenmore wind farm decision issued at the end of July, noting that both necessity goes both to the condition and the detailed terms of the condition, and that they should not be unduly prescriptive. And it's at that level we take objection with the approach that's being urged by Highland Council. We also note the burden that we place on the two other local authorities unless the Highland Council are suggesting a THC specific condition, and I'd have concerns about that if we go down that line.
Okay. Thank you. We're not going to get, I think, any further on this. Just to say, it's very much an issue we need to get our heads around. So, condition 19 is my next one. Operational noise. It seems to me there is a document of which I had no prior knowledge. Something from National Grid, which is apparently confidential. I don't know if the applicant can give us any kind of update as to whether you're able to make use of that document in the context of operational noise.
So I'll fancy it Ms. Taylor.
Thank you.
Yeah, just really to say that the applicant has engaged with National Grid on a number of occasions to inquire as to whether or not this document could be provided. The document is branded as an internal document to them, and they have stated that they're not able to release that document publicly. This discussion happened primarily in regards to the contour ceiling scheme, and through that they did indicate that the National Grid would be willing to enter into a sort of non-disclosure type agreement with the councils in order to release that. And that really that is where the position has stalled. But you know, in terms of our position, we're more than happy to facilitate that further engagement with the local authorities, and if the local authorities wish to take that forward. But it would be a case of not being released into the public domain is the current position of National Grid.
Right. Okay, that's interesting. I think it was Aberdeen Shire and the Highland Council who would raise this reference to National Grid. I don't know. Aberdeenshire maybe first. You see a way through this process where you're kind of advised of the contents of this document and able to use it without it becoming public? Can you see a way through this, how that might work?
Any form of NDA is a difficult proposition for a local authority to enter into, because as I alluded to earlier, we are bound by various other statutory regulations which require us to make information available, and have to rely on an exception, a statutory exception to justify that. And I do not have enough information before me to take a view on that. But I would say it's fundamentally very difficult. Also, from a practical point of view, there's some disquiet having to rely on a document for enforcement that's not publicly available, and the members of the public or any other party could not have any access to. I'm seeing no precedent for any such approach. So I'm prepared to engage in the applicant on it, but I've just set out that it'd be a very difficult one from a legal position to enter into. But I'm willing to engage with the applicant on it, but we'll maintain our position at the moment.
So would the deletion of the reference to that document and just reliance on the British standard, would that be insufficient, do you think?
I would actually have to, I can't actually answer that. I would have to consult with the members of our environmental health team on that point.
Yeah.
We'd be happy to do and respond on that even earlier than rather than defer it to closing submissions. I'll take that away. I'm back.
Thank you. I appreciate it. Yeah, I've no idea how suitable that BS is for the sort of noise that these things might produce, and whether it is, maybe the applicant will know a bit more about that, but that would appreciate that if you could just get, some guidance as to whether plan B could simply be delete the reference to this secret document and just rely on British standard. Other council, did you have some thoughts on that?
Well, thank you. Yes, I'll just suppose echoing Manisha's position in terms of there being this quite a fundamental issue in terms of transparency and public confidence in the planning system if it's if this condition relies on a methodology that isn't available to the public. I've had a brief conversation with our environmental health officer, and I think the view was that a document like this that is more specific to this type of development is quite important to include. How the two are reconciled. I don't know. So sorry. But that's it.
Difficult one. I mean, maybe if you don't mind, if you could ask them, I hear what they say, and it makes sense. A more bespoke means of measuring noise would be better, but whether they could live with, if they had to, just relying on that British standard, which is a very general applicability, if that's no use in terms of having a standard for this type of noise, then obviously it would be good to know that, so we don't try and rely on it. But if you can get some sort of advice, or indeed if there's another, I suspect there isn't, otherwise somebody would have identified it already. But if there were another standard that might, be suitable, then that would be good to know as well. Go back to the applicant. I appreciate you've done all you can. There is this issue of confidentiality, and obviously we hear what the councils have to say, which, especially things like FOI and expectations of transparency on the part of someone who maybe made a complaint to the council. They would kind of want to know why the council is or isn't following up their complaint on noise. I just wonder whether you had a thought on, if you can't use this document, whether general British standard document, which is quite commonly used for all sorts of industrial type noise, whether that would technically suffice, as far as you know, or you maybe don't know at this stage.
I'll just briefly respond to that to say that the document has been used as part of the EIA assessment as a methodology that we've adopted, and it therefore forms the basis of any future challenge or complaint that may arise through noise as an assessment methodology approach. And that would also, I suppose, link to change control and assessments that we would undertake through that process. I think it's inextricably linked to the EIA assessment and potentially the consent, and therefore we'd find it quite challenging potentially to remove that document as part of a condition.
Right. Yeah, no, fair enough. I don't know whether it would be possible to extract from that secret document and import into the wording of the condition whatever tests it contains without breaching its confidentiality. I suspect that might not be possible, and you might not want to go there. But if there was some clever way around it of setting out, in sort of tabular form, certain noise restrictions that apply in certain circumstances without annoying National Grid and breaching confidentiality, then there might be a way around it without. Then it's all public, it's in the public domain, and people know what they're working to. But I'll leave it with you just to see whether that might be completely over optimistic in that regard. It's confidential for a reason, I suspect, and that might be tied into it. So I don't think we can get any further on that one. The next one I had was the next condition, construction working hours. Really just the question of Sundays and whether Sunday working should be permitted. I'm aware of other Section 37s where Sunday working hasn't been permitted. I know the applicant has made some submissions as to why it's critical to the timescale and to worker well-being, I think, as well. So the the way the shift patterns work, that you are able to have the option to work on Sundays. Maybe just explain that in a bit more to me, a bit more detail.
Yes, again, I'll pass it to one of my colleagues who can give you some more detail on that.
Yes, good afternoon, sir. I'm Chris McDonald, Lead Delivery Project Manager. I think it might be helpful just to maybe give a context around the construction sequencing and the kind of development of overhead line works. I think it may help alleviate some of the concerns that's maybe over the last couple of weeks. So overhead line construction is typically different from potentially other construction projects such as wind farms, BESS, housing developments, where these are kind of largely kind of static sites, often with excess of 100 people, depending on the size of the scheme. And core overhead line tower site will normally only consist of upward of 10 core people working at a tower site at any one time. And impacts are not generally experienced continuously at all locations at one time across the full route. And I think that's pretty important to consider. Construction activities do move progressively from tower to tower in phases. An example of this would be when a foundation team complete their works, they will simply move to the next tower, which is some 300 to 320 meters, depending on the span length. And if you consider this, there will be respite for nearby receptors in terms of foundation half curing times, for example, where those activities will finish. The other follow-on assembly and erection working team would come after that curing period had been done. So in terms of kind of respite for those activities, there would be some for local residents and nearby receptors. And this maybe was considering that wiring generally doesn't start until the full section has been completely assembled and erected. Assembly working provides kind of flexibility really to manage weather delays. Obviously, there's some potential unforeseen ground conditions. We do know we've got several environmental constraints across the route. Sometimes at tower locations, there can be multiple environmental constraints, which actually reduces the working window to potentially 4 or 5 months of the year. And really kind of introduces the issue we have where we really have to work efficiently in terms of certain work activities. You did mention the kind of workforce welfare resourcing. So we do typically for certain activities such as foundations, tower assembly, overhead line erection, conductor wiring, they do typically work 11 on, 3 off. That is generally the industry standard. And the reason for that is they do tend to travel from further afield. And where it kind of differs from main construction or other construction such as wind farms and such like, you do require people to do extensive preparatory works. People need to climb towers to set up rigging. They need to make the worksite safe. And those in a general week can take 1 or 2 days. So if you restrict that, you're very quickly reduced to working. You reduce the productivity in those activities. And it is important to say that for wiring, they do work in large teams of upward of 60 over multiple spans, and they work as one kind of core team, so over several kilometers. And they do tend to work the same work patterns, so that essentially it's every second week they would be taking some time off. Again, that would allow residents to have some time off and some respite from those activities. It's probably important to highlight in around the kind of technical elements for crossing works. It does require us to take outages on the existing network and taking that into consideration, there is extensive requirements to ensure that we maintain a security supply, and in many instances may require to put that circuit back into service within 8 hours, depending on the circuit. So it's extremely important that we have flexibility to ensure that we are able to maintain that security supply on the existing network. The crossings and diversion scope, as you're aware, will take the full length of the construction period. We do have 6 crossings on this project that we need to consider and will take significant time. There's also point to consider is actually the activities that we'll be doing on the Sunday. They're generally low noise activities. We're not proposing to be doing HGV deliveries to and from site on a Sunday. The majority of the works will be preparatory works or core kind of wiring works, which are typically kind of low noise activities. As you stated, there are projects that we currently have ongoing just now. If I can draw your attention to the East Coast 400 kV upgrades, they're currently working a 7-day week for those wiring activities, and it seems to be working quite well, and they're able to manage that via the existing controls and mitigations that we have, which are robust. Again, we are committed to obviously community engaging with community, and if there are particular issues around instances where on a Sunday we are open to discussing that with residents on a case-to-case basis if there's particular issues. Again, Sydney working was assessed as part of the EIR, and it has informed this application. Provides some important program safety and workforce benefits. The impacts are temporary, localised and controlled through robust mitigation measures as detailed in the EIR. And obviously removing the 7-day working would extend the construction duration, increase overall disruption potentially to local communities, and delay delivering this nationally significant infrastructure.
So I think the only other observation to make in that context is the focused on the construction of the line, the foundations, tower and the like. Activities such as public road improvements or track construction or forestry works are works which would typically be undertaken Monday to Friday. So the flexibility is focused on that line construction for the reasons that have been given about how then the flexibility required for the network, the working teams that would be involved. But working such as public road improvements, track construction, and those sort of activities, the expectation would be a Monday to Friday with occasional Saturday work.
Right. Does the condition as worded make that sufficiently clear? It just says construction work, which is audible from the boundary, etc., is permitted to take place 7 days a week, with the exception of HGV movements. I just wonder whether you think what you've said, and I don't know whether it is defined, but whether construction work in that sense needs to be defined so that it is just what you're talking about and not the other works, which you say would only be during the week.
Certainly reflect on the wording.
Okay. Can I just ask, just for our education, is it possible to give a ballpark figure for how long the team would be in place, putting the foundation in, erecting the tower, and then moving on? Is it, we're talking weeks, months, just ballpark?
So look, these can vary significantly depending on ground conditions, foundation types, tower type, and they do vary. But in general terms, activities are specific phase activities such as foundations, are around a month. Assembly erection in month and a half. And these speak in very general terms and are highly, it's highly dependent on what we're actually building. And I think in general terms, I think we are looking at around a 5-month period of construction works at a single tower over the course of the 4-year period.
Right.
That is again phased in activities. That's obviously every time that is dependent on what we are doing at a particular time. So again, wiring is kind of unique because it does span several tower locations over several kilometres. And it's dependent again, going back to the environmental constraints, and for such long distances can be a significant factor for those activities. hence the flexibility requirements to do that is extremely important.
Okay, that's helpful. Thank you. Anything else on?
Final observation for me is the 7-day working was assessed within the EAIR.
Yes.
That was the basis on which it was done. And the point has been made that removing 7-day working would extend the overall duration, and so increase the overall period of disruption in relation to the construction works at particular sites where it had to be done.
Yeah, appreciate that. Did Aberdeenshire and possibly Highland as well have a specific concern with Sunday working? Was there anything you wanted to add to what has been said thus far? Maybe Aberdeenshire first.
Yeah, thank you, sir. I think Aberdeenshire is quite clear. We maintain that working hours condition is necessary to restrict on Sundays and bank holidays as our standard across energy-related development. It's a condition that we have applied with substations and other underground cables for offshore wind farms, etc. And that is really to ensure that there is respite for the communities that are affected. We're looking at communities who are going to be affected for quite a long time, a significant amount of time, and the 12-hour work and 7 days a week is effectively the majority of their waking hours, with the only respite during the evening. And I think what we need to recognise is this point was made during the community hearings a number of times, the concerns of the community and the effect that this will have the disturbance being continuous. So I think it's a balance between that and accepting that there is potentially workforce difficulties and timescale difficulties for the applicant, but I think we need to recognise the importance of the community in this.
Yeah, thank you. Mr. Wiseman, did you want to add anything from the Highland Council's point of view?
There's a couple of extra points I was hoping to raise. It's a point we do feel quite strongly about. I think the EIA refers to around about 4 weeks for tower construction. Obviously, let's clarify that's kind of a ballpark figure. There's obviously fell-in access track formation, and there's lots of other works that would go alongside that. Potentially there's areas of more intense activities around construction compounds, or if it turns out power pits are required around those areas. So I think to rely on natural breaks in the work just isn't really sufficient. It's not clear what they would be. It'd be very difficult to assess that and to control that. With that in mind, 5 months of 7-day working seems like a very long time. The condition, I suppose, is designed to cover works that are audible from the boundary of noise sensitive receptors. So I think the applicant just mentioned that there's lots of works that would be quieter. I guess they wouldn't be restricted, so perhaps there could be scheduling work done to accommodate that and work around this. I think just to echo as well what Aberdeenshire just mentioned, I think residential amenity is clearly an important issue, and I don't think workforce welfare should necessarily take priority over residential amenity. Final 2 points. I suppose there are major construction projects that take place with no Sunday working, so I think it clearly is possible to do that. And there is flexibility included in the condition for agreement in advance with the relevant planning authority if there are particularly urgent works that need to be done for a particular reason. So I think the condition that we've suggested strikes the right balance.
Okay, yeah, thank you. That's helpful. Aberdeenshire, your hand is up. Did you want to come back on that? Or was that an earlier hand?
Oh, thank you, sir. Thank you, sir. It was really just to pick up on a few points that I'd missed. Mr. Wiseman's kind of already picked up on that. Our condition, as we propose it, does allow for out-of-hour working requests for exceptional circumstances. So if there are construction activities that are, important, urgent, they can make that request to the council, and we can agree that in advance. And it was also to pick up on the point made by the applicant that it was to reflect on the condition wording to specify potential construction activities to be kind of Sundays or bank holidays. We would welcome that, and we would just like to look at that and comment on that if possible when available. Thank you.
Thank you. Yeah, that would be helpful. I'm just thinking of the timing. Maybe if Mr. Reid, your team could give some thought to that definition of construction works, I think was the phrase. If that could be confined to works on the line itself, as opposed to the other things you mentioned. If you provide the councils with some thoughts as to how that could be defined, if possible, then that'd be useful to have that sooner rather than later, because obviously if it were left to final submissions, then that would be after the council's final submission, so it'd be too late for them to tell us what they think. So if you are able to give that some thought and maybe a tweak to the wording, that would be appreciated. Anything else on that? No. Okay. Condition 21, archaeology, I had nothing on. Ditto, historic environment site protection plan, also nothing. And 23, which is the mains of Daviot, Rincon and Stone Circle. So I'm moving to the outdoor access management plan 24, really just, and I'm sure it's just my own inability to grasp the point. There was a request, point D, 2D. So this is the outdoor access management plan shall identify and map. And then point D is any existing areas excluded from statutory access rights under Part 1 of Land Reform Scotland Act 2003. I just wondered why it was necessary for areas that are excluded from statutory access rights. So presumably those where you wouldn't expect the public to be exercising rights of access because they don't have them. Why it was necessary for them to be included in the outdoor access management plan. Their access would already be managed away, or am I just completely missing the point? Question for, I think, Mr. Wiseman, because I think it's a Highland Council addition, requested addition. And anything else you want to say about this condition as well while you're on?
Okay, thank you. I think in terms of point D, it's just to have a clear picture of the access arrangements that are in place along the route. So if there are some areas that are already excluded, there may be more areas that need to be excluded on a temporary basis or as part of the development. So it's just to have a clear picture in the management plan about what the access arrangements would be. On the other points, I don't think there's much to add really. Just to emphasise that there are a lot of access routes and areas of access land that are not necessarily core paths or public rights of way. There are resources out there that would make clear where they are and where the most used routes are. It would understate the effect on access if those unrecorded routes were not taken into account.
Yeah. Okay. Anything the applicant wants to come back on this condition? I've got your written comments. If, they may suffice, but if there's anything specific you wanted to say, then please do.
If in my submission manifestly unnecessary, nor reasonable, and not capable of being defined with sufficient precision, there is no definitive source identifying all land excluded from statutory rights. So, position on that.
So 25 biodiversity enhancement, as I understand it, the applicant has a company-wide commitment to 10% biodiversity net gain regardless of any planning condition. And I think I'm right in saying that would be enforceable by Ofgem under the terms of the licence. Councils would rather that they had some control over this. They have better local knowledge. They would be able to secure the expectations of MPF 4 Policy 3, biodiversity enhancement, and are not content simply to rely on Ofgem's approval for this through this other process. I think the applicant is saying rather than have a planning condition, again, through some confidential process, they could advise the councils of what they are doing to satisfy Ofgem, and rather than have a duplicate process. Is that, Mr. Reid, is that kind of, am I summarising your suggested approach correctly?
Good. I'm going to pass you to one of my colleagues who'll give you a fuller answer.
Thanks. So on this one, we are, as you say, fully committed to 10% of biodiversity net team. We've got an established team and 10% biodiversity net gain. We've got an established team in place to deliver that. And the key thing for us is about the timing of this. These biodiversity enhancement projects are delivered with a really wide range of landowners, looking at community groups, charities, public and private landowners, and a typical project timeline right from the initial assessment and identification of those projects. We go through detailed surveys, which have to happen between March and October in the survey season. They go through a feasibility assessment, a management plan design. We finalise what the uplift and enhancement is going to be. There's then a really detailed commercial and legal negotiation to make sure that we've got rights to the biodiversity enhancement that's on that third-party land for 30 years. And then that kind of contracting and into final legal agreement is at least 18 months, with the kind of caveat on there, in fact, that if those detailed surveys haven't happened in that March to October window, that can really change that as well. There's also the potential for these to get right the way to the end of a commercial agreement and to not be agreed. We've already seen an example as a team where the cost was deemed too high to pass on to consumers, as ultimately that's where money is coming from. So we had to walk away from an agreement. It wouldn't be appropriate for us to spend endless money on these deals. The other point to raise here is that committing in advance of planning consent is really high risk. We're looking for opportunities to de-risk, and we've already mentioned the memorandum of understanding with the Highland Council, where we're working actively with their ecology team and planning team to take forward off-site nature restoration schemes to them for endorsement and approval, so that we can start investing earlier in the process. And as we've said in the previous submission, we would be very open to working with all the other councillors in that respect. In general, that's the key point for us, is we're really open to exploring an alternative to pre-commencement condition, but pre-commencement condition will unduly delay development, which would be a direct contradiction to the Chief Planner's letter from April 2025.
I might be misunderstanding, but did I hear right that where you've run into an issue with Ofgem, it was that you wanted to do too much rather than too little? And they were trying to sort of curtail you. I'm just wondering if that means that, I'm not saying that you would, but were you to put forward a scheme that wasn't actually very ambitious, you might secure Ofgem's approval on the basis that you're not wasting bill payers' money, but the council might be very unhappy that you're not doing enough. Is that a fair, does that not justify what the council is saying, which is we want to be involved in signing off whatever it is you're proposing to do? Or have I got the right end of the stick?
I think I'll clarify that point, sir. So that was a scheme where the cost was too high overall. So we were delivering, using the scheme to deliver 10% biodiversity net gain, which would have been acceptable to the council and would have been acceptable to Ofgem. But the overall cost of that scheme would have been too high to pass the cost to consumers. So it wasn't the principle of 10% net gain, which Ofgem are more than supportive of, and it would have been amenable to the council in question as well. It was the fact that the cost to deliver that scheme was too high. So that scheme, despite having that 18, in fact, that was 2.5 years of development, despite having that 2.5 years, we could not deliver that scheme at the end of 2.5 years. So we have pre-commencement condition. We run the risk of that happening on other schemes where the costs are too high to be passed on. Is that clear what you said?
Yes, I'm still thinking that if the council doesn't have a say in what is delivered, it's possible that for no fault of yours or anyone else's, whatever is delivered is a compromised, because the overall scheme cost hits a ceiling that you can't exceed. I'm just wondering whether presumably that would or would that be an issue regardless of who was signing off the landscape? You know, if the council was signing off a biodiversity enhancement scheme and they wanted X, Y, and Z delivering, and you were unable to get that past Ofgem, then would having that other approval process that the council was involved in actually not help, because you wouldn't be able to meet in excess of what Ofgem was willing to let you spend? Is that correct? If that makes sense.
I think that is right. So the commitment is to the 10%. Biodiversity. We are a regulated business, unlike a wind farm or other renewable developers. So we are accountable for the cost that is incurred. And I think you're right, so that the concern would arise if there was a requirement from a local authority to do something that Ofgem wouldn't sanction the cost of. Not achieving the 10% wouldn't allow us to achieve the 10% that way, then that causes possibly a significant problem at that stage. And I think it is important to keep in mind we are a regulated business subject to licence conditions which are monitored and enforced, which differentiates us from either a wind farm developer or other renewable developers.
Yes, no, I do appreciate that. That is an unusual situation that we're in. Does the council, I don't know who to go to first, Hallam Council maybe, do you see the point the applicant is making that they are committed as a company policy to 10%, but the manner in which that is delivered may be subject to a hard cap by somebody else, regardless of what you might want them to do, and consequently the benefit of having your sign off of the scheme might actually not deliver anything, because they might not actually be able to do what you would like them to do, and therefore the alternative is simply that they, on a confidential basis, keep you apprised of what their plans are, where they're planning to do things, but bearing in mind that ultimately final say as to how much of that can be delivered, it will rest with Ofgem because of the unique position that they're in. Do you accept that might be a reason why we should leave this to a different process? That I appreciate what you say about planning policy, etc., but this is not planning application, it's something else. But can you see where they're coming from, Mr. Wiseman?
I think first of all, it seems quite complicated of the sort of whether the applicant is actually required to deliver biodiversity enhancement. As we understand it, the real redetermination, I think it allows the addition of the cost of, it may need to put me straight here, but it allows recovery of the cost of up to 10% biodiversity enhancements, well, for that expense to be added to their TOTEX, which I gather relates then to what they can charge to recover that. So it may be there's other bodies that need to be satisfied as well, I suppose. But we would want to see that happen in parallel, because at the moment it's not clear to us that there will be a requirement for biodiversity enhancement to be delivered without a condition in place to enforce that. Do you recognise the unusual situation here, the involvement of Ofgem, but it's I don't think it's completely clear that those approval from the council and approval from Ofgem can't happen in tandem, essentially, so at the same time.
Thank you. Mr. Finley.
One of our issues, which we've highlighted and Mr. Wiseman touched upon, is we haven't actually seen the material upon which and the basis on which the applicant is saying that it is subject to such a requirement. And indeed, I understand that's a similar position in the Kintor-Teeing inquiry. There's been assertion, but no documentation. And we have a further issue about enforcement. Our understanding of it's an enforcement issue as well, and if they fail to meet their biodiversity enhancement, the enforcement process is simply a fine. by the whoever controls that requirement, rather than being able to force them to take action using planning controls. So we would request through you that if they're relying upon documentation, that is provided to us in sufficient time so we can comment on it prior to our closing submissions being made.
Yeah, no, that's another good point about timing. We can't leave this to closing subs. We need to know if there's something that the applicant can produce. We need to see that sooner rather than later. Come to Aberdeenshire next. I think you're the next in the queue.
Yes, thank you, sir. Aberdeenshire remains to be convinced at all that Ofgem has any role in this, and particularly for the reasons that Mr. Finlay has set out. In respect of TCAP, there has been further written information response requested from the reporter, with matters concluded with further submissions last week. And yet again, the applicant has made reference to the licence, Ofgem, and various other matters, but has not provided any of that in their submissions. So I would strongly request that if the applicant is to rely on their licensing provisions, that in this inquiry we have them provided, but we also be given further time to fully consider them finally as well. We've done a little of our own work in respect of the role of Ofgem, given the lack of anything from the applicant, and drawn similar conclusions to the Highland Council, which is Ofgem's role is very much at a high level. There is seems to be no way that there would be any enforcement in terms of lack of provision specifically for sites relating to this or any other development, which is a concern, particularly for Aberdeenshire Council, because unlike the others, we did not object, but our lack of objection was very strongly predicated on the basis that we would be satisfied that we would have delivery of the mitigation and it could be identified at an early stage. And the fact that the applicant is now saying that they are struggling to deliver mitigation on sites because of cost, and I appreciate that cost is an issue in respect of any scheme, does cause me some concern rather than give us any comfort. I've got further detailed submissions which were submitted in respect of TCAP. I'm not intending to rehearse them today, and I'll put them in closing submissions. But thank you for the opportunity to address this point specifically.
Thank you. No, that's helpful. I'm leaning towards this for this and a few other things that have cropped up where there's question marks as to what information we need to what sounds like has been the TCAP approach, where post the conditions session, further submissions on conditions had been sought, so that those can be dealt with in advance of final closing submissions. So that's where I am headed, because I think we do need information on precisely what confidence ministers could have on the effects of the licensing scheme and the applicant's commitment to 10% in context of expectations of MPF4, particularly for such a major project, and given the importance given to biodiversity enhancement. Murray Council next, please.
Thank you, sir. I won't repeat what my counterparts in Aberdeenshire and Highland have just said. I fully agree with, particularly on the enforceability side of things. The other matter I'd like to raise is, where is this biodiversity enhancement happening? The applicant is the network operator for the whole north of Scotland, in quite a large geographical area. If that's being done down in Argyll, there's no benefit further up north in Shire, Murray or Highland. So we've got huge concerns around that. But yeah, no, fully echo what my counterparts have just said.
Thank you. Back to Mr. Reid. So that's one point, is the need for whatever is delivered in terms of biodiversity enhancement to be local. I don't know whether you know under the terms of the license, whether that is a stipulation or whether it would be open to the applicant to provide it anywhere in the north of Scotland. But secondly, just I suppose put your notice that it sounds like we will be asking you in writing to provide further written submissions to convince us, if you like, as to why we could rely on the license as opposed to a condition as requested by the council. But I don't know if you want to say anything on either of those points yet, or if you just want to leave it until we write to you.
I think I'll probably prefer to give you a fuller position in writing. Two observations. The applicant did not say it is struggling to deliver net biodiversity gain due to cost. What it said was it was a scheme that Ofgem was not satisfied demonstrated value for money for consumers, and that Ofgem intervened at that point. So the suggestion that we are struggling to provide for cost was not said and is incorrect. The other point I would make is we are subject to a public law obligation to fulfil our licence conditions. So it's not entirely in a vacuum. There is a legal network or framework there because the licence condition exists, but I think I'll reserve my fuller position for any further written submissions that you choose to request.
Thank you. Yeah, my interpretation of that point was that it wasn't that you were, or it was an involuntary inability to fulfil the obligation because Ofgem were putting a hard cap on project expenditure, which was my understanding of what you'd said, but you can clarify what Ofgem's role was in that other scheme and how that affected your ability to do what you wanted to do and how that might relate to this scheme in writing. So we can talk about this for a long time.
Sorry, I didn't overspeak. Ms. Jones might be able to come back on the last points that you raised as well. So.
It's great. Yeah, I just wanted to clarify, there is no suggestion of any of the biodiversity enhancement being delivered outside the local planning authority. The way in which we measure biodiversity enhancement is through our biodiversity net gain toolkit, which all the councils should be familiar with from submissions and measurement of the on-site BNG. Through that, the way in which it is measured means that we will be delivering any off-site enhancement within the local planning authority area, and we're fully committed to that. I would also just like to reiterate that we are very keen to work with the councils to provide as much information under the right confidentiality and commercial sensitivity clauses of what that enhancement is and work with the councils on what it is in general. But yeah, just to clarify, it will be within the local planning authority areas.
Thank you. That's helpful. Thank you. Okay, I don't think we'll get any further on this one today. Commission work. Yeah, how are we doing? Oh yeah, fuck, it's 1:25. We're doing well in terms of getting through them. And I think some of my questions, at least, I don't know about points others wish to make. My questions are simpler for the remainder of the agenda, but we will need to have lunch at some point. I was thinking maybe 45-minute break for lunch. Would that be sufficient? And if we were to break now, before I go on to condition 26, my ability to add 45 minutes onto 25 is eluding me, but it's sometime after 2 o'clock. 2:10. Are we content to break now, come back 2:10? And we'll start with condition 27 onwards. Okay, great, thank you. Welcome back, everyone. Okay, so I think I said we'd come back and start on condition 27. I meant 26 because we haven't dealt with the habitat management plan. My understanding is the applicant suggested this be incorporated within the section 37 consent rather than the planning permission. So the Scottish Minister could take an overview rather than the three councils looking at their own sections in turn. And I think the format that's proposed would be similar to what we've talked about earlier about an outline plan at pre-commencement stage, and then detailed habitat management plans for each phase prior to, I think the trigger is cable stringing of that phase. Now, as I understand it from the note, the parties were hoping to continue discussions. I just wonder, Mr. Reid, whether you've got any further towards agreement on condition 26.
Asked to one of my colleagues. So.
Yes, so Aberdeenshire agreed the condition on the meeting on Tuesday, and Warwick Council's position is agreement. So there are some outstanding. Oh, I think there's only one outstanding point with the Highland Council.
Okay, good. Highland Council, can you confirm that, Mr. Wiseman, and tell us what that point is that you're still not content with?
Yes, like general agreement, so the approach of an outline and more details later. There's an earlier version of this condition which was a bit more explicit in what it required. It went into more detail about sort of covering the management of habitats during the period of construction, operation, decommissioning, measures, regular monitoring, review. It's just a bit more explicit, and I think we would prefer to see that clear requirement of retained. I think that is just the details, though, and the general approach would be acceptable.
Where would we find that earlier version? Is that on the 9th of July version? Is it a version that has featured in one of the committee schedules, or is it somewhere else?
We're looking in one of the earlier schedules. I do have the word in here. Don't know if what the nice way is.
What
Yeah.
we're going to do is just try and identify any little missing bits of detail from this session in writing with next week. So we'll fire an email out to the parties. So maybe that would be one of the matters to include on that email, just to say, is this hanging over? Can you just give us the fill in the blanks on that? So maybe that would be, we'll add that to the list as another, and then parties can comment on what the other party has said. And we'll explain later how we hope this will work, but have a short period for a quick exchange of points on the conditions before the deadline for closing submissions, so we can get that out of the way without delaying anything too much. Was there anything else anyone wanted to say on this condition?
Maybe just one point, Lauren.
Sorry, just to confirm that the wording, the previous condition wording is in the previous submission, from the 9th of July.
Okay.
Okay, fine. We probably don't need to ask for that. We'll just look at the two and compare them. I mean, if I guess if we still have a question as to why the Highland Council prefers that over the subsequent version, then we may, having seen it, if we feel we need to ask a question, then we will do that in the subsequent round of written submissions. We'll need to have a look at that. So condition 27 was community wealth building, and I think there's condition 52 local employment scheme, which similar sort of ground covered. I think your parties are going to agree on the matters. I think we just simply need to come to a view as to whether such conditions would meet, among other things, the circular tests. So I wasn't really proposing to ask you anything unless you particularly want to tell us something about those. No, I think we'll just have to come to a view as to whether that's appropriate or not. Condition 28, Papakali Species Protection Plan. my note says Nature Scott is content, yet to be determined whether RSPB Scotland is. The tweak, as I understand it, proposed by the applicant is that it shouldn't necessarily be confirmation of Capercaillie absence that permits work to proceed, but simply that the SQO confirms that there wouldn't be Capercaillie disturbance. Is that, I'll ask the applicant, is that my understanding of this sort of subtle tweak that you want to make to the condition, so that you could, as long as the SQO is intent that while there may be Capercaillie present, they wouldn't be disturbed or likely to be disturbed. That's the difference, is it?
Just to write this on the call, maybe in the first instance, you had a discussion with last week, so maybe in the first instance, best placed to offer any comment on that.
Okay. Yeah, okay. So on that question, if you can, the question is whether the wording, as I understand it, the wording that has been crossed out, it said works will only be permitted to advance into new areas, and it originally said once the absence of Capercaillie has been confirmed by the suitably qualified ornithologist. And the proposed alternative to that is works will only be permitted to advance into new areas following confirmation by the suitably qualified ornithologist that no Capercaillie breeding activity likely to be disturbed by the works has been identified, or where a necessary mitigation and construction proposals have been agreed in writing with Nature Scott and RSPB Scotland. So I just really want to work out whether parties think it's essential that Capercaillie are confirmed to be absent, or whether this more subtle approach whereby the SQO might not be able to confirm absence, but is willing to confirm an absence of harm to those Capercaillie that might be present, whether that's sufficient. I mean, I suppose Dr. Parish, I guess, would be an interesting, as I understand it from the note, you are content with that. I don't know if it's you or maybe perhaps Ms. Heatley who wants to deal with it. I think Ms. Heatley's got a hand up. But I'll turn to you then.
Would probably be best placed to offer more detail on this, but my understanding is that carrying out the checks to see if there would be a disturbance could themselves be a disturbance, which is why the more nuanced wording is generally preferred. Dr. Parish, do you have any comment to add on that?
That in essence, that's it. Yeah. I mean, ideally, the most important thing here is that wherever possible, no work is done in Capercaillie relevant areas during the breeding season. That's first and foremost. But then, if something is deemed essential, it's very difficult to see how that should advance, because checking for birds can itself be disturbing, and we know Capercaillie are extremely sensitive to disturbance. So, and you know, identifying whether the birds might be disturbed or not, and having confidence in whether they would be disturbed is very difficult to do. And in trying to get that information, you could cause the disturbance you're trying to avoid. So I don't know if there's any way that the applicant can clarify exactly what they would do, what the thresholds would be or something, but we would be slightly concerned about that. Our thoughts first and foremost is avoid, wherever possible, doing anything in those sensitive areas during the breeding season.
Yeah, okay, that's helpful.
If I could add a comment to that, sir, it's just to say that Nature Scott's comments on this condition are subject to their understanding that the details of the SPP itself remain to be approved, and that in the context of approving the SPP, Nature Scott will probably seek specific measures such as tower marking, which is not in the outline SPP as we understand the applicant has submitted to date. We'll also need to deal with the geographic extent of those measures, and the duration of them, ideally seeking protections for as long as the structures are in place and not just for a 30-year period. And if I might just expand on a comment made earlier, Nature Scott's generally happy with the multi-stage consent approach, but would reserve its position in respect of things like compensatory measures in future because there's not enough information about those. And assuming that all mitigation measures proposed to date fall within the area of SSE's way leave, Nature Scott does not see any need for a Section 75 at this juncture.
Right. Okay. Thank you. Would given that the applicant's proposal, as I understand it, is for this condition to be attached to the Section 37, which would mean it would be ministers who would sign it off. Given Nature Scott's role as advisor to ministers, would you prefer it to be that way? And I'm not saying that you don't trust the councils to handle it correctly, because I'm sure you do, but would it make sense to you for the sign-off to be by Scottish ministers in consultation with yourselves and indeed RSP Scotland? Do you think that makes more sense than putting it on the planning permission?
I think in our experience, kind of key physical operational requirements such as this tend to go within the planning conditions section, but I don't think there's any objection in principle to it being within the scope of the Scottish Minister's decision making in Section 37 as well.
Thank you. Thank you. That's helpful. Mr. Wright.
Thanks, sir. I just wanted to come back on some of the comments from Dr. Parish in relation to the extent of where these measures would be implemented. So Part A of the condition does set out that we'd just be looking to implement these, or looking to implement these based on where we have records of capercaillie in the last 5 years. So providing that comfort that we are targeting areas where we are likely to have capercaillie, and then the presence of capercaillie there would be confirmed through those check surveys. The wording that's been proposed is in response to the request from RSPB Scotland to address their particular concern there. But also, as stated, the finer details of how this would be implemented would be subject to agreement within the capercaillie species protection plan, and that would be agreed with Nature Scott to get that agreement.
Thank you. No, that's all very helpful. I'd got the wrong end of the stick. I was assuming that a definite commitment or a definite confirmation of capercaillie were absent was a good thing, but in fact I now obviously realise that's not necessarily a good thing, because to get to that point you need to have been rummaging around the woodlands and causing your own disturbance. So very helpful. I now understand where we're all coming from. So condition 29, which is the Heathland Habitat Management Plan. I don't think I had any queries on this. I think this goes back to what we were talking about last week as to whether it's the 11.2 kilometres or the 7.1 or somewhere in between. Unless parties want to raise something specific, I think we just need to come to our view as to what one should refer to. Any need? No? Okay. 31, 32. 30 I didn't have anything on, which was peat and carbon rich soils. I'm assuming that's, sorry, yes, Nature Scott.
Yes, apologies, slow trigger finger there. Just in connection with condition 29, we agree that the definition of relevant parts of the development remains to be confirmed as a separate matter. But we were wanting to seek some clarification on some of the existing references to towers and the extent of heathland planting. We understand that the applicant's proposed wording refers to several towers in the second line there, the last of which is CB66A, but we consider it should actually be CB69. And that the reference to the derogation case document should actually be Annex C, document 006. If the applicant could confirm that, I think we might have comments over and above those anyway, but if the applicant could confirm those either now or separately, we would be very grateful.
Right. Yes, I can't remember off the top of my head, but I think you're right. Annex C was the thing that had the plan, I think. But I don't know if you know, Mr. Wright, off the top of your head, the number of the towers and whether there's a typographical error in there or not. But if you don't know, don't worry, we can check that. As I say, we need to come to our view as to which areas we're talking about based on what we discussed last week.
Yeah, thanks, sir. I think we'd like to confirm that in writing, if that's okay.
Yeah. Fine. Well, we'll have a look. If we think that we are uncertain, we need to ask a question, we will do that next week and you'll have a chance to clarify. Okay. So peat and carbon-rich soils, I didn't have anything on. There's 132 private water supplies. Ms. Allen, I know that's a concern for you. I don't know if you've had a chance to go through the conditions. As far as I understand it, the councils are happy that they, and indeed SEPA, I think, be that would provide sufficient protection for private water supplies. But obviously, as someone who might be on the receiving end of any problems, if you don't agree with that, if you could explain to us why you don't agree, or indeed if you do agree, then that's fine.
Thanks, sir. The monitoring and so the conditions point 1 seem to be acceptable. What I don't see, and they may be somewhere that I haven't had a chance to look at, are the mitigation measures.
Right.
So should something arise, what happens? I'm not seeing what the detail of that might be.
Is that point 1E, contingency plans that will be implemented if adverse impacts are identified? These should include timescales for notification of relevant stakeholders. I assume that would be someone like you, and for design and implementation of remedial actions. So I think that might cover it.
It might. I suppose it's that bit about timescales. You know, you've got livestock at risk, etc. So I think we would wish to see detail of that, because if it's not detailed, if it's not said now, and if there's not baselines prior to commencement, then there's not much reassurance and no legal standing really for anybody with a private water supply.
Did the applicant want to come back on that?
I don't think I've got any observations. I've heard what's been said, and Frank, I'll just change. No.
Okay. I think all we'll have to do is have a good think about whether that wording, which I suspect is fairly standard wording, does the job. We can't take it any further than that, but I suspect it is wording that has been used elsewhere.
Yeah, I suspect that, but we also know there are problems elsewhere and legal wrangles ongoing, so we'd like to avoid that where possible.
Indeed.
And I think it's that bit about having some comfort, and that doesn't really give comfort of detail and timescale that people can be assured of having water that day for their animals.
Yeah, well, yeah, clearly that is critical. Okay.
Thank you.
Points, we'll bear that in mind. Thank you. I had nothing on 33 GWTEs. Or 34 flood risk, or 35 bird flight diverters, assuming everyone's intent on those. And 36, in common with, I think, 44, which is public road, 36 is borrow pits, 44 is public road improvements, 46 is temporary construction compounds, 47 is modifications to distribution network, and 59 is temporary accommodation. All of these, it seemed to us, might get tied up in questions of what is and is not part of the project and how they can be dealt with by a multi-stage consent condition. So I didn't want to talk about that issue again necessarily. But if anyone wants to talk about anything else, conditions, then I'm very happy to hear it. So starting with 36 borrow pits. Highland Council, Aberdeenshire Council still not content. Island Council to start. I'm just trying to read my notes as to why you're not content. Maybe you could shortcut that by telling me.
I think possibly yes. For the reasons you've just set out, really, so that we've already discussed around the extensive EIA projects. And I suppose to emphasise the point as well about whether the effects are identifiable or not, and if they are, then I suppose our view is that they should be assessed at the point of the principal decision, rather than being a matter for condition.
Yeah, I can see it now, and that's the same point of Aberdeenshire. I think it's that question again, the eternal question as to implications of the regs and possibly Ray Shaw's decision. So I don't know. I'm assuming the applicant doesn't want to add anything necessarily, but unless you're welcome to if you wish.
No, I think I've been repeating the discussion earlier, so
fine, good. So that will knock out several that we'll come to later as well. So 37, I had nothing on aviation charting and safety management. I think that's a standard condition. MOD is happy. 38, landscaping scheme. I think this relates to off-site areas of mitigation landscaping. Ms. Anderson was talking about benefits of that, and some of the people on site that we met was also indicating or asking whether it would be possible to have some off-site mitigation planting done. And I think we spoke last week about the practicalities of actually securing that on third-party land. Reading my notes. The Highland Council is content with this one. Murray Council, Aberdeenshire. The note says still reviewing the wording. Is that correct? I'll start with Murray Council. Are you content, or is this still to be discussed, or are you unhappy?
We'll defer to our closing submissions, but I think you covered it there that Ms. Anderson on our behalf raised concerns about the lack of landscape mitigation. He mentioned also the concerns from the community, and indeed we heard that at the community session in Tunnis the other night as well. We've listed in detail what's in the inquiry report from Ms. Anderson, and be keen to see that reflected in the condition. But like I say, we'll defer to our closing submission.
Okay, that's fine. Aberdeenshire, did you want to say anything at this stage?
No, it was just to confirm that we did speak with SSEN on Tuesday, and we did confirm our acceptance to the wording as proposed.
Okay, thank you. Okay, well, I think we'll probably just park that for now, and you'll both be able to tell us what the possibleness of doing anything currently proposed. 39 Caledonian Canal. I think this is the issue about moving that one tower. This is an area that Council has confirmed it regards particularly sensitive. I think the note says waiting response from Scottish Canals. Is that because they need to agree vice position of where you were thinking of moving the tower, Mr. Reid, or is it something else?
The moving this is about moving or really legislating the tower at that point. It's to do crossing the canal and the effect on the canal of the works when you're there. As I understand it,
okay.
This correct response is awaited from Scottish Canal. I think the 13th of August was when they were last written to 3 times. Yeah, and that was the 3rd time they had written to for a response in relation to this proposed condition. But there's a slightly different issue to address that.
Okay, so it's things like how you do it to avoid harming the canal, and right. Okay, fine. Okay, and it's right. You're still awaiting Scottish Canal's feedback on that. Yeah. Well, we can't wait forever, so we'll need to come to a view on that. But obviously, if you do get some feedback, do let us know. I had nothing on the landforms conservation method statement. That's condition 40 or 41, which is the Torvian landforms version, or indeed 42, which is Cordlewood SAC and Moniac Gorge. I think was an H. Scott condition that the applicant has agreed. Or 43, telecommunications. G4, public road improvements. This is one where I think the Highland Council, I think that all of the councils, in fact, are not content. Let's see what my note says on this. Okay, this is the this is the one we talked about before. Yes, this is another of those multi-stage consent ones. That's fine. We'll just have to park that for now until we try and work out what we're doing with those. And there's more of them, I think. 45 decommissioning plan, I think everyone's happy with. 46 is another one of these temporary construction compounds. We'll park that. 47 is another one, network modifications. So 48, I think we get to, which I think is to be deleted, my note says. Is that right? This is specimen tree planting. I have a note that says to be deleted. I'm not sure where I got that from. Applicant, can you help me out on that? Did I dream that?
Speak to one of my colleagues.
Yes, sorry, yes, this is to be deleted. So Highland Council proposed a number of tree-related conditions, and we then proposed deletion of some of them and combining some of the requests into other conditions. So this was one that we had suggested could be deleted and incorporated into a different condition that's further down.
Oh, okay, right. And Highland Council, did you? Oh yes. Oh, it says on the note agreed. So that answers my question. Mr. Wiseman, just nod if you're.
Yes, yeah, as the applicant just explained, yeah.
Excellent. Good. So 49 is agreed. 50 ground reduction plan is not agreed by the Highland Council. My note says we need to decide whether control requested by Highland Council over ground reduction works is reasonable, necessary, etc. We just seem to need to come to a view on that. This is a matter I think just raised by the Highland Council, but there's the issue about whether we should have one condition that relates to the entire route. So that's another factor we need to bear in mind as to whether, in the absence of any concern from the other two councils, whether we need to have this condition biting across the whole route or not. Did you want to say, Mr. Wiseman, anything on this crime reduction condition? We just simply need to come to a view as to which side of the argument we prefer.
There's maybe a couple of things, I suppose, in terms of the purpose of the condition. I think it fundamentally primarily relates to kind of ancient woodland and woodland of higher value, with the intention being that there's crime reduction that takes place rather than felling, so the woodland is retained. I think this goes beyond what the schedule of mitigation commits to. So I think there are some references to crime reduction being considered, but it's not as robust as this condition. There was a point the applicant raised around the trigger for it, about whether it needs to be a pre-commencement condition or whether it could be a no crime reduction works take place until it's discharged type trigger. I think on that, I don't think we'd be necessarily comfortable with it being sort of prior to any crime reduction works, in case that creates a bit of an incentive just to not do them if there's sort of extra condition discharge required. But some sort of phased approach, kind of looking at section by section, seems proportionate and be acceptable. So I imagine there's probably some word in there that can be agreed. But I guess that was it for that one.
Thank you. Okay. 51.
Sorry, so maybe just on reduction plan to just through the applicant's position, it's not necessary, and one gets support from that, from the fact the other two planning authorities don't consider it necessary. That doesn't go to whether we need it specified, that goes to necessity and whether Circular 498 is satisfied. But it might be one of my colleagues might be able to add just a few observations about current reduction plan, which may be of assistance.
Good afternoon, sir. Matthew Atkins, Senior Town Planning Specialist with Scottish Hydroelectric Transmission. So I suppose key point to make is, if we're talking about crown reduction, there's a real danger here of getting beyond the ambit of the planning system in terms of such activities are not development. We're not talking tree felling here. So I suppose to further what Mr. Reid was saying, this is not necessary and it's not really relevant to planning per se either.
Good. Okay. Understand. Murray Council next.
Thank you, sir. Just a quick note of concern I would say was we appreciate where Highland Council are coming from. As a smaller authority, we don't really have the resources for considering these impacts on crime reduction plans. We procure our tree specialists from outside the council, and taking account of significant we'd be quite concerned with that. So,
okay. So if it were to wash over all three councils, I guess if you don't have the resources to respond, you could just, provided that the condition silence as agreement, then you could just opt not to deal with it. If
the danger for us would be that there's a degree of, as touched upon by the applicant, obviously there's a wider felling capacity planting look at it. Something that's kind of as bespoke as crime reduction plans. The one factor is not the resources to do it. Our concern about just being included in that condition is for them the expectation by many residents that we would have the capacity to enforce that condition and see it through. When in truth, I don't think we have the resources to do that. I think it's not. I know that resources isn't a material consideration. I think just more generally, it's where there's other conditions that are talk about failing, etc. Perhaps the issue is kind of covered. There's obviously an ongoing issue with them, maintenance of crown power lines that occurs anyway, separate to the planning system, and which really wouldn't be something that we would normally get involved with. Thank you.
Okay, no, thank you. Aberdeenshire Council, please.
Yes, thank you. It was just to say that we have not made any comment to the proposed condition because I don't believe that we have any ancient woodland affected within Aberdeenshire.
Oh, thank you. That's helpful. Back to Mr. Wiseman.
Thank you. Sorry, I'll keep it brief. Just to come back to the applicant's point about whether this goes beyond the remit of planning. I think it's quite common for conditions to control things that are not development in their own right. Things around tree protection, I suppose once development has an impact on trees, I think there's an impact there, and that if there's a benefit to conditioning climate reduction or other sort of arboricultural works, then I think that is something that can be and regularly is conditioned. So I do disagree with that.
Okay, thank you. Right, 51, arboricultural impact assessment for abnormal indivisible loads. I think the issue is whether it should apply only to specific categories of AILs. I think the applicant says the majority of this isn't like a wind farm where you have colossally long vehicles. We're talking about, I think the applicant says the majority of vehicles are cranes, which would be, in terms of roadside tree implications, not a lot worse than a typical articulated lorry. I think that was you again, Mr. Wiseman, possibly on the not being 100% happy with that condition. Is that right?
This was a condition that we suggested.
Way around. Sorry, you wanted it. So they're saying they don't think you need it because the vehicles aren't that dissimilar to a regular lorry. What do you say to that?
Yeah, I guess what we're interested in is vehicles that might oversail the road or might have an impact on the tree canopy. So if that change to just covering special order vehicles covers that, then that would be fine.
Okay.
It looks as though from what what the applicant has mentioned in their notes that the Cat 1, Cat 2 vehicles potentially are slightly wider. Don't know if that has implications in terms of oversailing. It's maybe worth considering as well that some of these roads are perhaps may not be suitable for HGVs. But that's yeah, I don't know. But fundamentally, yeah, we just want to make sure there's no impacts on trees along the route.
No, I understand. I mean, presumably some farm machinery, I suppose it's the combination of length and width maybe that causes the problem, because I'm thinking of farm machinery that is a lot wider than 2.5 meters or indeed 3 meters, but it maybe doesn't have the length, so you don't get the combined. I don't know if Mr. Reid has an expert on abnormal loads. If not, don't worry. I think Highland Council is content to have this provision in for these special order vehicles. If you have any, do you want to come back on that, or do we simply need to come to a view as to what control, if any, we need to have on this type of thing?
I think one of my colleagues might be able to make 2 observations that might assist.
Yeah, that's fine. Thank you, sir. I think we would be happy to have the condition for special order. I think that would be a reasonable approach. I think we could end up unnecessarily causing an admin burden for everyone, considering the actual significant volume of HGV movements and potentially crane movements. Also, the PRI project also addresses issues around rural roads, where we are proposing to cater for a split path on those particular parts of the development.
Thank you. That's helpful. Thank you. Right, 52 we've already touched on. We just need to come to a view on that. Local employment. 53, I think everyone's content. Just for my own education, I'm assuming that this is aviation lighting. I'm assuming, given the height of even the tallest of these, we're just talking about infrared illumination. Is that right? You maybe don't have a person qualified to talk about that, but I'm assuming, I'm just comparing it with the turbine, where the threshold is 150 meters, where you need visible lighting. Am I right in thinking that we don't need to take account of visible lighting on any of the towers? Sorry to spring this on you, it just dawned on me when I was running through them.
Yeah, I'll pass it to my colleague.
Yeah, so we have consulted with the CAA and MOD on both of these, and there is no requirements being identified for anyone in infrared or visible lighting.
And can I just double check that definitely includes the Caledonian Canal Tower, which is much taller, and I know that tall towers of that height in other locations, for example, Kincardine, do have lights on them, but just to make sure that one doesn't either.
Yeah, that was included as part of the consultation.
Excellent, thank you. And 54, public art. Again, I think this is one where we need to come to a conclusion as to whether we think it's reasonable or not. We're not at the point in discussing it. I've got what you think in writing on both sides. You're not going to agree, I'm sure, so maybe we'll just have to come to our own conclusions on that. Condition 55, which is the community liaison group. I think the point was you can invite third parties to take part in that group, but you couldn't require them to. Therefore, the group, in order to be a properly formed group, community liaison group, it couldn't have to have third parties involved. And I think that was the applicant's point. Does anyone disagree with that? You simply need to offer the opportunity to get involved, and if people don't want to, then that shouldn't be a block to it progressing. They're on content. That's reasonable. Yeah. Good. Getting there. 56 active travel. Was this Murray Council? This was no, it's Highland Council, I think, who had some concerns on this. Here's my note. So this is a condition requested by the Highland Council. Related to land south of National Cycle Network Route 1, south of Nairn, which overlaps with some of the construction traffic routes. So it's a request for a specific condition, which I think the applicant disagrees with, because I think you say condition 24 would cover it. I'll ask the council first just to explain what you're seeking to get out of this that condition 24 wouldn't give you anyway.
It's yeah, I think the way it's been dealt in the end is sort of specific to this location, but the intention probably was actually for it to cover the scheme more widely for locations where there are there's potential for conflicts between active travel routes and construction traffic. In this particular area, it's National Cycle Route 1 runs along the construction traffic route, and I understand from colleagues at the council that there is pretty much an off-the-shelf scheme available to reroute the National Cycle route so that it's not that conflict doesn't exist. So the purpose of including this condition was to try and implement that. I think that probably goes beyond the wider kind of outdoor access management plan condition. But that was the background to this.
Understood. Okay, so back to the applicant. I mean, it sounds like there is a ready-made solution to this problem by rerouting cyclists somewhere else. That being the case, can you live with condition 56? Assuming that it's just applied to this one specific location for which it appears there is actually a solution in place.
Hi, my colleagues at the moment. So I've just got to notice on my screen, Ms. Allen had lit up as she had her hand up, I think, when we were discussing aviation lighting, that had subsequently gone down. It might be you want to hear from my colleague and then check in with Ms. Allen as to whether there's something she had wanted to contribute.
Thank you. I'll come back to it, Ms. Allen.
Thank you, sir. I mean, as we previously set out, the construction traffic management plan, we're committed to that and reasonably necessary safety measures. With condition 56, it's a very broadly framed condition. It's not too clear from that what is being sought and where, and it is so broad that it gets into the territory of being not precise and not reasonable. So that gives us a significant concern. So.
Okay, so to come to a view on that. Thank you. That's helpful. Ms. Allen, Mr. Reid's a lot better at spotting your hand than I am. Please, my apologies. Do come back.
Not a problem. Probably an answer I can get elsewhere, but it was actually in relation to condition 22 and the earlier one about socioeconomic benefits. It was really just a question as to where planning legislation now stands against community wealth building legislation, because that has come in subsequent to the application being lodged. So it's just to pose a question.
There's a good question. There's a discussion or a disagreement between the parties as to what I think as to whether those matters are material to the decision on a planning case, but whether the planning system ought to get so involved in those issues that it ought to actually try and enforce those measures by a condition. So it's if there's a promise to do something good for the community or to offer opportunities for local employment or something, that's a good thing, but the weight it could be given might be limited by the ability to actually nail the applicant down to delivering it. But at the same time, the constraint on being able to nail the applicant down might be caught up in Mr. Reid has referred to several times the conditions circular, which has various tests that apply to what is a legitimate approach to take, and there are certain constraints, legal constraints, that the courts have imposed upon planning conditions as to what is appropriate to try and control, and there is a limit to what the planning system can actually control. So it's a bit of a grey area as to somebody might offer something but not necessarily be able to be pinned down to delivering it, which will limit the amount of weight it can be given as a tick in the plus side of the equation. So the answer is it depends, and it's probably fair to say there's nothing, as far as I'm aware, nothing actually concrete that will say they will definitely deliver X, Y, and Z towards community wealth building or local employment. There are commitments to, the best that they can, but subject to, we need to decide, which is a dispute between the one side of the argument saying, well, it should be actually enforced. It should be written into a condition, so they have to do it. And on the other side, saying that would be a legally inappropriate condition, therefore it can't be put into a condition. That will affect how much weight we can give to any sort of promises if they can't actually be guaranteed. That's a very rambling answer. I don't know the answer.
I actually understand your answer, and I see where you're coming from, but it is the query of almost hierarchy of legislation, because with this new legislation coming in, does it actually impose greater impositions and standards on other legislation? I don't know. I was just posing it.
It's a good question, and we need to have regard to all, and ministers, of course, ultimately who are making a decision, ministers' own policies on a range of matters, not limited to planning necessarily, will be in their mind when they come to the decision. So ultimately, they need to make a decision that is within the scope of they're allowed to do with their electricity and planning song. So that's up to them as to where they go with that. But we will offer them some guidance based upon what you and what the council and what the applicant have told us as to where the line stops in terms of what they should and shouldn't take into account, just in the context of the decision on this case that they must make. So we're not there yet, but we will have to be in that position fairly shortly, so we can offer them advice and they can take it or not as the case may be. But yeah, good question.
Thank you.
So where are we? We are 57, arboricultural method statement, tree protection plan, and 58, veteran tree management. This is another, it's a Highland Council proposal. Are they both Highland Council proposals, I think? Sounds like there may be a bit more agreement. I'll come to Mr. Wiseman first. So 57, 58, more tree related stuff. Are you, those two are getting agreement on these? Am I right or am I misunderstanding?
Yes, I think we pretty much have an agreement. The only point was around the precision of the reference to kind of in the vicinity of these trees. So I think we would just like an insertion that says it's up to the arboricultural consultant to determine what's in the vicinity of. Yeah, and that was it. Otherwise, I believe we're agreed on that.
Okay, applicant, any problems with that clarification?
No, I don't. Sorry, I'm very passionate. I'll just.
Yes, yeah, no agreement, no issues in principle with agreeing wording, but we just need to go through that process before agreeing final wording.
Thank you. Right, 59, temporary accommodation. We're parking that again for the same reason of all the others. Flood and mitigation scheme. I think we don't have Hez's comments, sorry, Environment Scotland's comments on this, unless that has changed. I don't know if you know, Mr. Reid, if you've had any input onto that.
Pass my same colleague will be able to help me with that.
No, this condition was received by the applicant from the Highland Council on the day we submitted this draft schedule, and as far as we're aware, that hasn't gone to HES for any review or comment.
Okay. Okay, so we will be getting shortly, I think, some confirmation of the council's concerns with regard to Culloden, which we'll need to take into account. And as part of the applicant's response to that, I guess the applicant could respond to the necessity and/or detail of this condition. So maybe we just park it for now, see what the council's formal position is on the Culloden effects, and based upon that, the applicant can respond to this at the same time. I think that's probably the easiest way to do that. And in the meantime, HES might hopefully have come back to us as well.
Proceeding that basis, our position is that there are no significant effects at that location, which we explored and that last week. We'll come back more fully in the manner suggested.
Thank you. So then 61 was we've talked about this briefly before. This was I think there's two things. It stipulates what has actually been approved under this consent or this permission, and it also incorporates the sort of redundancy thing in the event that the line turns out not to be needed anymore, and it shall be decommissioned, because there is no finite lifespan given to the permission. I have seen others where I think 80 years was stipulated. I'm guessing the absence of that from the schedule means nobody thinks that's a necessary stipulation, and instead simply, if it's not required anymore, then decommissioning should be, it's not required for 12 months, decommissioning should be put into place. But I don't know if we need to say anything more about the first part, the scope of the works. I think I understood why the council wanted this, and we need to come to a view on that.
So perhaps I could just add something on that.
Please.
If you look just further down the page, just trying to get online, the proposed conditions do provide for a definition of development, which would be put in Annex 1 Part B, which I don't think exists any longer at the moment. And our understanding is that is commonly attached, with a consent maybe for a wind farm or for an overhead line. And that would be an alternative way of defining the development, but raising it in the condition, certainly the first part of the condition, draws attention to it, which is highlighted by the racial considerations we've been through. That may be an alternative way of defining the development as to what is permitted, or you could do it by way of condition, but one way or other, the development needs to be defined somewhere.
Okay.
That's all I wanted to say about that, and the second part I'll leave to others.
Thank you. Yes. Mr. Reid, do you have anything to say on, or indeed anyone else, anything to say? I'll come to you, Mr. Reid, first on Condition 61. Anything in response to this Highland Council condition? I think you said at the time of your note you haven't had a chance to review it. Have you yet had a chance, or your team yet had a chance to review it, or do you need more time?
In relation to the first part, our position would be that it's not necessary to make the development except on planning terms. If consent is granted, it will be deemed planning permission for the elements specified in the application. So there's no need to restate that in the condition. In relation to the second part, I have very real reservations about the lawfulness of a condition which would put in the hands of the planning authority here to whether to decommission transmission apparatus for electricity, that being a reserved matter. I also am not quite sure where we get to if the planning authorities took different views on whether it should be just decommissioned. Also, whether to route electricity through that line would potentially be a UK government decision for reasons the UK government would not share with us, let alone a local planning authority. So I have very real reservations about the lawfulness of the second aspect of that.
Yeah, that's interesting. Presumably, might it be that a 12-month cessation of transmission might not necessarily equate to no future need for the line for whatever reason? You say the UK government might suddenly decide they've changed their mind and they do want to reroute it back down this way, in which case, presumably, it would make no sense for it then to have been taken down in the meantime. So, okay.
Yeah, one of my colleagues, Mr. Brown, might be able to make a few helpful observations as well.
Thank you, Nick Brown, Deputy Project Director for Beauly Peterhead scheme. It's not our control necessarily about what electricity goes down the line. It would be the National Electricity System Operator. We are a transmission owner, so we operate the system, but it is the Electricity System Operator that would dispatch whether energy is put down that line or otherwise.
Right, that's interesting. Yeah, okay. That's another factor we need to bear in mind. Good, thank you. That was very interesting. I think that's the end of the conditions. Surely not. I think it is. Just what else I had. I suppose the other question, which I promised earlier, was: are there any other matters that ought to be the subject of a condition or planning obligation? Speak now, before it's too late. Anything that's missing from this list? Murray Council.
Thank you. And so this is, we're raising this because it's literally just raised its heads to Section 36 energy consents that we're dealing with. Understand the kind of the format of the consenting in these situations has a time limit contained in the Section Electricity Act portion of the consent, and there's a deemed consent, conditions that follow afterward. What we found is that the first condition, which we have before us just now, that identifies a time limit, more than 5 years, isn't reiterated in deemed consent. So we've got an issue just now in several wind farm consents where, unfortunately, having to seek a variation in the Electricity Act to extend the duration of the consent. And there is no appropriate similar condition under which they can seek a Section 42 variation time limit in the deemed conditions. And I understand from the other side that they've been told that there's the Electricity Act cannot deem consent to under Section 42 to vary the time limit. So it's just food for thought. Might it be appropriate? Hopefully necessary, but to have a mechanism there, a condition, the deemed consent that reflects the first condition that we have before us about the time limits for commencement, just so that there is a mechanism in there should it be required to seek a variation to Section 42 to extend the deemed consent. I'll leave it with you, but just have something that's raised its head twice now. And one of the cases that we've come across, there isn't actually a deemed condition that would suit the purpose of extending the duration of the consent, fortunately.
So there's been no parallel conditions, one on Section 37, one on the Planning Commission that have the same effect.
Oh, apologies, sorry.
But I
think there's a bit of debate earlier on about the need for that, but I think that maybe just underlines the need for that condition. I know those discussions with the applicant, there was questions about the duplication there. So
apologies on drilling through the Electricity Act consents at one time.
I'm just wondering if Now you've got me thinking, if there is no ability to vary what we're calling condition 1, which would be attached to section 37, I assume, I don't know, somebody might be able to help me, that I assume there is a need to have a time limit condition on the section 37. I'm just wondering if it wasn't essential to have a section 37 time limit condition, could we simply just have condition 8 and have the time limit on the planning commission? I suspect the answer might be no, but that would have got around the point you make about it being impossible to vary the section 37 time limit, because they would have been able to vary at section 42 of the Planning Act to vary condition 8. I don't know if anyone knows whether that's possible.
Sorry, the two wind farms that are discussing just now, I think they're unrelated, and I think that the common understanding is that they need to be dealt separately. One was Circuit 36 have to deal with variation, and that was separate from the deemed consent. I think both ways. Yeah.
You're saying they had to reapply for the wind farm effectively to get a new duration, a new life.
Yeah. Well, one of them has a condition, mercifully, that for other reasons ties it back into the Electricity Act consent. Other one, which we've just received, loosely has no condition. We're still in discussions with that developer about how they extend the life of the consent. They may be stuck. They may have to reapply. So,
right. Okay. I mean, going back to Mr. Reid, I assume you have no intention of allowing the 5 years to run out. By the sound of it, your client wants to get cracking immediately. And I don't know if you know the answer. I certainly don't, but I suspect the expectation, at least, is that section 37 has to come with a finite lifespan, and that we couldn't simply omit it from the section 37 and just attach it to the deemed planning. I don't know if you know the answer to that, but I suppose my simple question is, I assume you can live with time limit condition on both emissions, given that you've no intention of letting it run up to the 5 year or 2 year or 3 year, as Mr. Kelly would rather it was.
Made the applicant's position clear on its desire to make sure it meets the long stock date that it's bound to deliver this project by. On the technical question of law, I'd rather think about that. And I can confirm either way. I'm not going to give you an answer now.
That's fine. Yeah, that's fine. I was putting you on the spot somewhat. Okay, any other matters that we need to talk about, either conditions or anything else? Obligation? No? I don't think so. No? Okay. Any other matters anyone wants to raise? I think my colleague, was going to just run through chronology of where we go next in terms of the various submissions and additional information that's in the pipeline. There's quite a few confusing deadlines, so I think she's got a head round what needs to be submitted to us and what we're going to submit outwards to you. So I'll hand over to her, but just nothing else that anyone wants to say or do before I do that? No? Okay. I'll hand over to my colleague.
So we have talked previously about the timetable for closing submissions, but obviously there's been a few tweaks to that. So I've worked up a slightly revised timetable, but importantly, it's still based on us meeting the December target, which we're very focused on. We'll do our best to deliver that. So in terms of our sort of preferred timetable for the next steps, I think by the end of this week, we should have the agriculture additional information submitted by the applicant, and we should have the Culloden further written submissions submitted by the council. There's a few things that we will come back to you on. Actually, some of the points of clarification that we had, some of them have actually been answered today, which is helpful, but there's still a few more. And I think there are a few questions that we'll have on conditions that we'll want to express. I think we'll plan to do that by the 3rd of September. That's next Thursday. And then I think a fairly short time scale to respond to that, because I think they will be largely points of clarification, factual points, rather than anything else. So by the 10th of September, that's 1 week to respond to those points. My understanding is that the publicity for the agriculture environmental information will take place during that time. So I think the 7th of September has been mentioned for that, but the applicant can confirm that. So by the time we get to the 10th of September, we should have the applicant's response on those points of clarification, including, I think, would be helpful to have a final set of conditions. It sounds like there's some useful sort of movement towards agreement on a number of the conditions as of the discussion today. So I think if we could have that set out, perhaps a final set of conditions then if possible, if not in the closing submissions. The closing submissions for the other parties, not the applicant, would be now the 24th of September. And that would be addressing the matters that have heard in the oral sessions. That wouldn't include agriculture. And alongside that, the other parties can offer any other comments on these points of clarification that we'll be asking around landscape and visual and on conditions. And then closing submissions for the applicant on the 8th of October, covering all the matters, again, not including agriculture at that stage, because I think that's also the same sort of timescale for the publicity on the additional information. I think it closes at that time. But the applicant could provide further comments on those landscape and visual points of clarification. If there's anything that they want to respond to what the council said, they can do that at that stage, and also to respond on Culloden points from the council. So assuming that the agriculture publicity ends at that point, then I think we want to provide another opportunity for the applicant to comment on that. So by the 22nd of, that's slightly separate from the main closing submissions, unfortunately. And the reason for that is so that we can push on and, you know, get going with the parts of the report that we need to get going with. So it might be preferable to you to have that all together, but I think for us, in terms of moving forward, we would prefer to have that coming slightly later. So there's quite a lot of dates there. I hope that's clear. If you want me to repeat any of those, please ask, or please give us your views on whether you're content with those. Perhaps Mr. Reid first.
I've made my position clear previously on any departure from the previous dates. I've made clear that that will cause considerable professional and personal difficulties with timings having been planned on what was published and what we expected to be adhered to. But if those are the dates, they will have to be worked to. We do know that priority guidance requires a report to be with ministers no later than week 46 in the process, and we are comforted that you're continuing to work towards that, and that aspect of priority guidance will be respected.
I mean, just to point to, the priority guidance does flag up that if additional information is required, that the timescales may not be met. I'm sure you're aware of that. But that said, we are still very much trying to meet the timescales that we've publicly said so far. So we believe this timescale will allow us to do that. So hopefully others can contribute as required. Is there any comment from the other councils? Any other parties want to comment on those timescales? Mr. Finlay?
No comment from the council. Thank you very much, Madam.
Thank you. And Murray, are you content?
Yes, content. We appreciate if you could confirm I'm right, ma'am. Just
yes, we will.
Relevant parties. Thank you.
And Aberdeenshire?
Yes, thank you, ma'am. Very content.
Okay, that's great. Anybody else want to comment on that part of the process? If not, I will pass back to Mr. Weir.
Thank you. Yeah, just really to say thank you all very much. Commission sessions are not much fun usually, but we found it very helpful. Cleared up a few misunderstandings that I had, and we've got an awful lot to think about in terms of what we do, especially with multi-stage consent conditions, etc. But it's been very helpful to us to get your input. Thank you all, not just for today, but for the whole inquiry process. It has been very good, handled very well by you all, and we're not anticipating any further process. So the plan is to close the inquiry today. I hope that remains the case. So I will close the inquiry. Thank you all, and we'll see you anon. Thank you.
So very briefly, I made some brief comments last Friday, but it would be remiss of me not in front of a wider audience to note that the applicant recognises a very substantial amount of work has been done to prepare for these hearings, and more generally to consider and give careful attention to this application, which the applicant brings under its obligations as it has under its licensing condition. Both you, sir, and ma'am, the work that's been done to do this, but we recognise the councils and everyone else who's engaged with it, including a number of local communities and individuals who have put in a lot of work to contribute towards a technical issue and recognise affects them considerably. So on behalf of the applicant, I would want this to close without us recognising all that everyone has done to consider this important application and give it proper attention. Thank you.
Thank you, Mr. Reid. Thank you all. Goodbye.